Millard. For Lordship perusal Millard. Yes. This criminal misconduct.
Saturday also you.
Most urgent also can get a half glance, Millard. What happened, my lord, in this CRLMC, my lord, informant challenging the order of a recalling petition, my lord. Next page, my lord, lordship kindly have a glance. This matter was listed, my lord, as per lordship direction. Serial number 60 thila. Chetri avoid hela notice को नेला नहीं. He accused नेला नहीं. Informant has come, my lord. Next page, lordship kindly that order dated. Your lordship smooth to कहीं पर इंडा typical mistake है जी. First CRLMC number more 4808 to 2024 जगह 25 है. Second, your lordship kindly paragraph 2. Law and Council for the petitioner directed to take steps for service of notice through IIC. My lord, Seman Navarta. You will also directed me. Third one, my lord, leave this matter 25 March, 25 May, 25 Joda vacation, my lord. That was, my lord, the typical matter, I think, my lord. Last, my lord, second notice you also directed me. Say, what
do you want now?
My lord, second notice, I mean, third page, I lord, kindly notice receive for salary. Urgent, my lord, at a 376, my lord.
You move an application because already there is a date, there is an order. I can't change it unless there is an application. You move application, I'll mention it.
After the memo,
memo because there is an order already. I can't change the order. Wrong, right, whatever. There is an order.
Wrong,
maybe typographical error, but you move an application and mention me Monday, I'll take it Tuesday. Tuesday. Okay. You move an application, formal application. Narrating.
But I file the application.
Fresh admission 205 rejected. 138 no. Another
Belgium. Yes. Yes. Let us start. Anybody wants adjournment? You tell me.
39.
They need not wait.
39 hearing weekly.
39.
Item 29.
Then let us call the page wise. Let us call.
1 to 9.
Yes. Yes.
10 to 24. 25 to 29.
29, my lord. Here, appellant number 2, main man, has been died. I have to take instruction regarding for it.
The appellant
number 2.
No.
Petition number 2 has been died. So I have to take instruction because I have sent a letter. It has come up with that he has died.
1 minute. Petition number 2. Okay. Let us consider the petitioners submit that he has got the instruction that petition number 2 has expired. He needs he seeks an adjournment to get instruction from the other petitioners. Yes.
Date.
Yes.
Okay. 1 week after anything.
He'll give it. Yes.
Oblige.
30 to 36. 37 to 39.
Yes, 39. What?
39.
What do you say?
Lordship, in item 39, I am for the petitioner. Mr.
Yes,
Jina has come from Delhi today. Let the matter be taken up today. He's on his way to the court, to the honorable court.
But Mr. Maharana has some personal difficulty.
Lordship.
I'll adjourn it. Let him come and argue. Let him do his part. Okay, you come.
Lordship,
We'll see. Yes.
Item 1.
May please. The matter of settlement and also yes, boy child has been born out of the.
What are the offenses?
376.
376.
No, your law.
Is continuing underage. 17.
17 plus. For that reason, your lordship tell them to come on. They have come on 24/4. 25/4.
No, then they are going to marry or what?
They have
already married.
But how can
they have not married? But out of wedlock, there is a child.
there is no wedlock.
I would say wedlock, but that is not the wedlock.
Now they have to wait till
your lordship has
No, he is correct there. What he says, how the court will give a seal of approval in a minor marriage.
That also, your lordship has order dated 21/5/2024. For that reason, your lordship is adjourning the matter, granting interim order for 6 months thereafter.
Let the interim order continue.
Because your lordship has told me to bring them. They have come.
I'll just record their
Because
presence.
it is not
Presence.
covered by your lordship's judgment.
By your-
But see, I can't give a seal of approval of
No,
marriage of.
Because 17 clause is going on now. As per certificate.
Let it go. I have stayed the proceeding.
Yes, ma'am.
Let it be stayed.
After 6 or 7 months.
He may
Uh,
come.
Right on.
Your lordship will record their presence also.
Yes.
Informant as well as victim.
Right on. The petitioner and opposite parties, all the opposite parties.
Opposite party no two.
Opposite
Because
party,
daughter is not-
petitioner and opposite party number 2 are physically present today in the
And
court
victim also.
along with their parents, along with their parents and victim. Victim on the ground of settlement. The petitioner is seeking quashing of the FIR. Since the victim is at
17 plus.
present 17 plus, age of 17 plus 17 years, about 18 years, about not yet attained the age of 18 years. I'm not inclined to entertain this petition at this stage. Hence, the same is
Inclined like the laws.
No, I'll not say. Simple, not entertaining. At this stage, Mr. Vishwal, London Council for the petitioner seeks an adjournment. Release the matter on such day after 8 weeks or 10 weeks for late June. And interim order pass on
24/5.
21/5.
21/5.
21/5/2024 shall continue till further orders. Till further orders I have done it.
Until further.
Let them attend.
Yes.
Yes.
Two,
Not right. We can file the joint affidavit. Both the petitioners are present.
What are the offences?
Offenses, your lordship,
341,
294, 420, 506, 34.
What are the allegations? Let us see. What have you done?
So the allegations is that in a Ganesh Puja, so the
Immersion ceremony was there.
immersion ceremony, there was like some, the car, they stopped the car and they broke the car window. That is the allegation.
Gadiku?
In Ganesh
This
Puja's
is-
immersion ceremony, your
Okay.
lordship. The joint affidavit was filed, the informant was supposed to be present, but
Lord, informants
And this
mother has,
Thelapela Kole and
Yeah.
scolded.
Yes.
Yes. Right. Where are they?
Lord, informant mother has been hospitalized. He could not come, my lord.
The informant has to be there. How?
My lord, he could not come. His mother
Can he
is
come?
supposed-
In the VC can he appear for?
I have to call him, my lord.
you can take a.
Ask him if he can appear through VC
My lord.
for 2 minutes also. I can
We can take a
dispose
pass.
it up.
Your lordship.
Let it-
I've just passed it over. Huh?
Fine.
Just check it. If she can't come, then we'll see what can be done. Yes. Just for whenever he is there, you just come and tell me so that I can pick up that matter. Okay. Yes. Yes.
item 3,
Item 3, my lord, on the basis of a protest petition, my lord, cognizance has taken on 1/8/2024, my lord. Summons were issued, my lord, on the same day of 1/8/2024.
Yes.
My lord, on 21/10/2004, BW was issued. Thereafter, my lord, on 10/1/2025, my lord, NBW was issued.
By order dated 21/3/2025, the JMFC Bhubaneswar has taken cognizance of offences. Where is that offences? Offence
My lord, page 45, my lord.
45.
Page 45, my lord. Order dated 1/8/2024.
Taken cognizance of offences punishable under section
406, 425,
06. Where is that here?
20. Page 45, my lord.
406. 40?
Page 45, my lord. The order. Page 40, starts from page 44, my lord. Order dated 1/8/2024.
1/8/2024. 406, 420, 506, 34 IPC. Reading section 25 and 27 of Arms Act. Subsequently, thereto, due to the absence of the petitioner in the court on 10/1/2025, NBW has issued. NBW has issued. You are on bail?
No,
Issue. The petitioners are not admitted to bail as yet. On inspection, Mr. Naik, Land Counsel for the petitioner submits that his clients will be appearing before surrendering before the court on or before 30th of April and resort to the remedy to them under law. It is open to the petitioner to move application for grant of bail, urging all the ground as has been urged in this petition. If such bail application is moved, the same shall be considered by the courts below on the same day. Yes.
my lord, what happened is that BW was issued. It's a protest petition, my lord. Cognizance are taken.
It's all right. You will get the bail.
Because the NBW say BW प्रथमे सम्मान करथिले
All right, now I have cancelled it. Why do you worry?
What happened, my lord? It's a protest petition. FIR was lodged on the basis of a complaint petition, my lord. FIR final report is that it's a false case.
The present case is arising out of an protest petition filed by the opposite party number 2.
Opposite party not 2, my lord.
Opposite party number 2. Initially, the FIR was registered against the petitioner, which has ended up by the final form filed by the investigating officer on 30th/11/2023. Thereafter, a protest petition has been filed. In the protest petition, cognizance of the offences under section so has been taken by the impugn order so. Subsequent thereto, NBW. Yes.
He will be admitted to bail, my lord.
Yes, yes. Yes, next.
Item 4.
Give the dates. Give the dates.
Bail 8/12/16. NBW 1/8/23.
10/8/23. Prayer it is 10/8. Certificate copy also 10/8. 10/8. 10/8. Okay. Yes.
Item 5.
May I please, my lord? May I
Yes.
please, my lord?
Fine.
I'm through busy.
Yes, yes. Tell me the date.
My lord, NBW was issued order dated 2/2/24.
Bail.
Bail was granted, my lord, 13/6/27. 13/6/2017.
27.
Running page, my lord, 14.
19. Yes. Got the date? Yes.
Item 6.
6 my lord, NBW issue on 2/5/2024, my lord. The last page, my lord. Page 8, my lord.
Bail. I know that I can get it. Bail. When you got the bail?
Bail, my lord, 3/1/2020, my lord.
3/1/21. Okay. Yes.
Item 7.
My lord, petitioner released on bail on 26/5/2022 and NBW 25/3/2025.
Okay. 5. Yes.
8.
Yes.
25/2002 you released on bail and the warrant to issue number 26/6/24.
Okay.
9.
9 May please.
The present petitioner has been released on bail in 17/1/18 and NBW issue was issued on 9/3/2022.
Okay.
Obliged.
22.
Obliged much.
Item 10.
With the permission of you plead to BC, my lordship. My lordship, it's a bail job matter, my lordship.
Yes.
Bail date is not there.
My lordship, the petitioner has not provided the bail number and it was, he is on bail since 2018, my lordship.
Since 2018. NBW issued on
16/3/24.
16/3/23. Okay. 5.
Item 11.
Item 11, my lord, released on bail 3/4/23, my lord. NBW issued on 21/2/25, my lord.
Okay.
12.
Date of NBW is 4/1/2025. Petitioner 1 released on bail 13/3/2020 and petitioner 2 was released on 1/5/2018 your lordship. Two petitioners there.
ठीक है each कर दो
Item 13.
NBW was issued on 21/8/2024. Date of release 13/8/2020 your lordship. By this honorable.
okay
minus 14,
14 May places. The present petition is released on bail 1/8/2023 and NBW issued on 25/9/2024. Obliged to mercy.
15,
May I please, my lordship? May I please, my lordship? The petitioner released on bail on 2018, but NBW issued on 18
Give
to
the dates, give the
2020.
dates.
18 2025 is date of NBW. 16 1 2018 is the release and bail.
Okay.
Released on bail.
16,
NBW student 17 to 25 on the date of judgment, petitioner could not appear. Check bounce case.
Prayer ticket 17 12 লেখা হয়েছে এটা 72 হবে
17?
2025 হবে কিন্তু 17 12 2025 এই যে প্রেয়ার
Sir, corrected in the court.
17 2 2025
হবে correct
17 I think he is corrected it.
That's it.
Yes. 17 bar he is corrected it. Okay.
17,
Obliged.
Yes, my lordship, I mean DC lordship. Proceeding under section 138 of NIA, NBW was issued on 5th of November 2024.
Okay.
18,
Release on bail Miller 1/5/2023. NBW 22/4/2024.
20
2
to 24.
2024.
19,
May I please, my lord? Petitioner released on bail 27/12/2014. NBW issued on 25/4/2024.
24.
Sorry.
Yes.
20, item 20,
date of NBW and the prayer of the IO the NBW is issued on 7/12/2024
Petition was upturned. Okay.
back there service on the prayer of the IO
Yes.
21,
21 on the prayer of the IO, NBW has been issued.
My lord,
Showing the petitioner as absconded.
19 and
13 no to establish.
2021 relating to same matter, NBW was issued showing the accused as absconder, my lord.
It's all right. Yes.
22,
22 the case NBW was issued on the 6/9/2024 and he was absconded, therefore
NBW issued on?
on 6/9/2024
The dates are altogether
dates
different.
are different dates. Last date is the
24, no? Item
18/2/2025.
24? 22. 22. Just the prayer, it is written something else. What is the date?
Yes.
Was the order dated 21/6/2026 to 2016 and 10/8/2017?
But the date of the order sheet shows that the NBW has been issued on 6/9/2020. It was to be executed, last date is 27/11/2000.
Right, the NBW against the petitioner was issued earlier on 21/6/2016, which could not be executed. Hence, on 10/8/2017, once again NBW has been issued. তারপরে করতে স্টেপের মাধ্যমে বাস more than one each করবো
23,
This given on the petitioner bail on 22/6/2022 and the NBW issues on 13/1/2025.
24,
Rather, presentation of release on bail 4/12/19, my lord. NBW issue on 4/10/24.
yes CMB
25,
yes. Are you there in 25? What is this? Huh?
acceptance of draft notice for paper publication.
Code this up. I know code. Huh?
Fixing next week.
Next week. 4 weeks after 4 weeks. Huh? Yes.
26,
May I plead your lordship? My lord, I am in BC, my lord.
Yes.
My lord, in one cause of action, 2 FIR has been lodged, one through 1CC complaint case and through another through FIR. Notice has been served, but
Who is
unfortunately,
appearing? Are you appearing?
Your Lordship, I am filing for OP number 3
in CRMC 175/25. I'm offering today. So Lordship, kindly urgent for some other date.
In
File always absent. File always absent. File.
Five is
OP number 3. I'm applying for OP number 3.
3.
And filing.
You are appearing in OP 3 in the connected matter. 175.
175.
In 175 of 2025, so and so entered appearance for opposite party number 3 and 6 in adjournment to file Wakalatnama and response to the petition, release the matter after 4 weeks. Yes.
My lord, in this case, the lower court proceeding is going on.
What to do? Service is not complete.
My lord,
You have to complete the service.
I'll take, if Lordship give me permission, then I can take the special messenger to OP number 5.
OP number 5 special messenger. Okay.
Deeply obliged.
Service on opposite party number 5 is awaiting. Let it counsel for the petition directed to take it. Yes.
Deeply obliged, my lord.
Yes.
27.
27. What is this matter?
Short adjournment, Your Lordship, because informant
Adjourn.
could not be made available.
On the request of petitioner. Yes.
28.
And Your Lordship, my lord.
Yes.
In this case, my lord, that for hearing. And because I am custody near about 5 years, and I had moved a bail application.
Let us come to the appeal if you are ready.
Here, my lord, PW.
Are you ready?
My lordship, yes, my lordship. But my lordship, I think I have to also file a written notes of submission, so it will be easy for your lordship. Because they have only.
No, I have listed it because he has already undergone about 5 years.
But
He has moved an application for bail.
But
So I said, let us see the.
But last occasion, my lordship, I have sought the judgment, chains in judgment, where your lordship has. I have kindly have a glance to para 22. My lordship, only one paragraph.
Then, my lord, to the different interim objection, my lord, paragraph 4 of the Ravi Prakash.
Let me see.
Because my
Ravi Prakash is in a different line already.
No, chains 2025 judgment, ma'am.
Because, my lord, submission of my state council for in consideration of interim bail, my lord. For bail, 37 is bad. So far, the 37 is concerned, my lord, twofold. First is the, my lord, opportunity to stay. That has been, my lord, complied.
Yes.
Second is the, my lord, whether, my lord, after religion bill, he may not will, my lord, commit the similar type of offense. To that effect, my submission, my lord, is prolonged incarnation. My lord, dispense with the 37 also, my lord, second point. Since a person custody near about 5 years.
If you, that is your proposition, you are the way you are. Show me the judgment. Does it say that prolonged incarceration?
Paragraph 4 of Ravi Prakash.
That cannot be
For a
taken.
moment, my lord.
With regard to the civil condition of state, that is let count for the state is her.
That's why in many cases, my lord, in many 25 kilo, 50 kilo, how to do in chemistry bill. It is 37 kilo.
The information.
Nowadays, my lord, 37 is bad.
Not found to be that the petitioner is not guilty. The same to form, but the state will. Now.
ମୋର ମାସେ 2 ମାସ ବେଲ ମାଗିଥିଲି ହଜୁର ଯାଇକି କିଛି ପଇସା ପତ୍ର ଆଣିଥିଲେ ହିୟରିଂ କଥା କାଇ ଦେଲିନି ନହେଲେ ବି ମୁଁ ହିୟରିଂ ଠାରୁ ରେଡି ହେଇକି ଆସି
No, the problem, I'll tell you, the problem is in Ravi Prakash, it is under trial. Here you are.
No, trial on conviction, all the Miller on the way stand Miller 37 back. That's why Miller may not consider at the stage of trial UTP or Miller after conviction. Only because 37. Otherwise, nothing Miller. So for 37 Miller paragraph 4. Not only Ravi Prakash, many more judgment.
Also, that also discuss about the.
Anyway, this is for bail. Let us come to the main appeal. I'm not interested to unnecessarily waste time.
Yes.
Let us see the appeal first.
Yes.
Appeal.
I filed my detail note, Miller. First of all, Miller.
Let him argue and you note it down and
Yes.
I'll put it for you.
Yes.
Paragraph, Miller. Here, Miller.
Give me the note. Give me the note.
Okay.
Give her a note.
ତାଙ୍କୁ ଦିଆ ହେଇଛି କୋର୍ଟରେ ବି ନଟା ଅଛି ସ୍କାନ ହେଇକି ଆସିଛି
Scan ହେଇକି
କିନ୍ତୁ ଆଜି ଯେହେତୁ ଆଇଏଟା ଆସିଛି ସେଇଥିପାଇଁ ହଜୁର
ନାଇଁ,
Order still still.
ଅର୍ଡର ଆସିଛି ବୋଲି
Yes.
ସେଇଥିପାଇଁ ପୁଟ
Where is the note? Written note of submission. Come on, let us. Read it.
ପେପର ବୁକ୍ ରେଡି ଏଭ୍ରିଥିଙ୍ଗ
Yes.
Milord, PW 17 is the informant.
Yes.
Look into the Milord evidence of the PW 17.
PW
17.
17.
On 29/1/2021,
Okay.
I was posted as SI at Town PS Balangir. On that night, Milord, at about 1:38, I was on patrolling duty with my staff. I received information that one vehicle bearing registration number so and so was coming from Milord Sointara side carrying ganja. I intimated about the information to IIC Town Police
No,
Station.
you don't read the entire evidence. You tell me what is your point and point out to the relevant part.
Yes, Milord.
If you read
Milord.
it,
Yes,
then
Milord.
it will take 3 days.
Yes, Milord.
Come to the point.
Yes, come to the
Yes.
point. Here my first submission is the Milord section 42 not compliant.
Not compliant.
As because the information received by the Milord I concern IO not noted down in the writing. That is Milord state away Milord in their deposition.
Or 42 not compliant.
Yes, Milord. Cross examination Milord 7. I could not note down the information in writing as I was on the way of patrolling. Then, Milord, I have not mentioned paragraph 8. I have not mentioned paragraph cross examination, Milord. 7.
Yes. Cross para 7.
7. Now, not note down the information. It is the Milord mandatory to, after getting the information, to note down the same and Milord, of course, and that has to be Milord sent to the higher officers, Milord. Then the higher superior Milord officer than the informant, Milord.
Yes.
That is Milord. Then Milord, cross I have Milord not mentioned the phone number in the affair from which I intimated regarding the information to the IAS.
Para 9.
Para 8, Milord. As because in affair, Milord, he only stated their compliance of the section 42, just a simple manner. I intimated the IAC concern, but not mentioning which phone number mentioned that, Milord.
Yes.
Apart from that, cross Milord, section 55 of NDPS Act, Milord, safe custody is doubtful, not compliant. State away, Milord, paragraph clause 21. It is not a fact that I have given Trimanama of the impression of the brass seal, Milord. It is not a fact that no brass seal was given. It is a fact that I have not noted down.
Then your case is, since he has not given the phone number.
Not given the phone number. Not note down the information fact. Fact 42 did not note down the information.
Then your case is, he should have been noted down and intimated to the IAC. So the noting down is not there. Noting down is not there. Phone number is not there. Obviously, he is not.
Apart from that, Milord, that information should back to the higher officer, just like SDPO other than the IAC. Then, Milord,
in chief, has he said that I have informed?
Chief Milord question, but then पढ़ुଥିଲି सबुरा. I intimated about the information IAC town PS etiki made SD entry and intimated the matter to SDPO SP Balangir as well the SD. Se कहउछन जे Milord chief से सेटा कहउछन trust नाही. Then Milord paragraph 24. Say it's 24.
Yes.
Say the pramanikon that I have not noted down the information in writing even after arriving at the place.
Okay.
Suppose Milord on the way it's paper. I am because it's a Milord information getting on patrolling. Someone difficulty to note it down the same. But after arriving,
also he is not noted.
Noted down. That is the 42 not compliant. Then Milord, to that effect, Milord, come to the.
Where is IO?
IO after hoju. This is the both kotha ache. IO Milord after.
No, you only emphasize in 42. Section 42, this is what?
सेटा तो आपला का पकड़ Milord. Out of our की जासी होगी जो information पाएगा.
Regarding 42, what else?
Yes,
what else?
Then Milord, IO पकड़ Milord. Section 55 Milord. I call 55 Milord safe custody of ganja. Section 52A Milord. Inventory not done. Turn upon the sample Milord. That is a procedure Milord. 52A of the Milord.
I am asking something else. Insofar as 42 is concerned, do you have anything else to say?
No, Milord.
Let us complete 42. Then we will go to 55.
Yes, I can 42 IO Milord 17 evidence Milord.
Is enough for court.
Yes, Milord.
Okay.
তাদের আর কিছু আছে।
Okay. Now let us come to 55.
PW 18 IO
Section 55.
কেবল আছে পারিব 42 ଆଉ ତା ସେ কোন আছে খালি ইনফরমেশন পাইলা তাও রকিলা কি নকি তারপর মিলর আইও ইনভেস্টিগেশন
Section 55. Oh, yes.
section 55 and 52A Milord.
52.
Can I Milord wrong read Milord something to see through?
Yes. Read it.
On ATP, I was posted as SI at Town PS Balangi on that day about 2:20 p.m. SI so and so presented a written report before the IIC Town Police Station, who registered the PS case number so and so and directed me to take up investigation. During course of investigation, Milord, it's important. During course of investigation, I visited the spot and prepared the spot map, examined the complainant and other witnesses at the spot, arrested the accused persons namely Santosh Singh and Ramachandri, both are the petitioner, Ramananda Chaudhary, intimated the family members of the accused person regarding their arrest, seized one command certificate on production by the so and so, examined other witnesses. On ethics, I forwarded the accused person. On ethics, I forwarded the accused person. Here, Milord, on this person, Milord, it's clear that he had done everything. Milord, after took up investigation, he went to the spot and Milord made a spot map, arrested the accused persons, intimated to his family member, everything he had Milord done. Even if he stated that he seized the command certificate, everything, but he had not stated that he seized the contraband article. In this person, Milord, he stated he had done everything. He went, Milord, made a spot map, arrested the accused person, seized the command certificate, and intimated the family member.
Except seizing the contraband, he has done everything. That's what you want to say. Yes.
That's not doubt.
Yes.
Then Milord, seized one command certificate. Examine other on ethics, I forwarded the accused person to the court, produced the seized exhibits before the court. Sample was drawn before the sample was done in the court. In view of order of the court, the ganja packet so and so the Malkana town place Balangi, the Malkana registration number so and so register, dispatch register of town police station. Here, Milord, this person stated that Milord, in Malkana, the contraband article, after brought by the concerned Milord IO to the police station, that has been Milord kept in the Malkhana of the police station. But the Malkhana in charge in this case, Milord, also not examined as the witness. Even if the original Malkhana register, as it Milord evidence from the judgment, that has not been produced during course of trial.
Yes.
That's why my Milord doubtful section 55 Milord. Milord, he brought the kept the ganja in Malkhana Milord, Malkhana Milord, and to that effect maintain the Malkhana register. But during course of trial, Milord, the Malkhana in charge Milord had not been examined. Who may prove the Milord Malkhana register? Ganja Malkhana received the Malkhana in charge Milord examine in the case proper. Then Milord, next page. On 31/2021 ACD, I see the detailed report submitted by the IIC Town Police Station at Balangir and prepared schedule list. I released the same report in Lima advance. So I obtained the order of copy of the sub-collector Balangir regarding deputation of executive magistrate for seizure of ganja. On ATP, I seized one command certificate on production by the so Ramachandra Bhatta and prepared seizure list. On ATP, I examined the second owner of the seized vehicle at the PS and seized copy document of.
He doesn't say anywhere that he has seized the ganja.
Something is there, Milord. I have to check it. Second paragraph, this is said, Milord, this said affair already marks on so Sangram Kesari Patna ki this is a spot map, report bonus. Then Milord come to the statement with the cross, Milord. Milord, I took first, Milord. I took charge of the investigation on ethics at 29/1/2021. See the Milord date of occurrence and time Milord. Then Milord date of a law. I have not paragraph 9. I have not taken the charge of siege article before my investigation of this case Milord. I have not taken the charge of the siege article before. It is a fact that prior to my investigation, the siege articles were received in our police station, police Malkhana. That also proved that Milord, the concern I will not seek the Milord contraband. Because Milord, prior to investigation, ସେମାନେ ଗଞ୍ଜେଇକି ଥାନାକୁ ଘୁଣି ଆଣିଥିଲେ। ତାମାନେ ଲୋକ ରହିଲେ ସେଠି ଆରେଷ୍ଟ କଲେ ଗଞ୍ଜେଇଟାକୁ ଆଜ୍ଞା ଘିନିକି ଆସିଲେ ଗଞ୍ଜେଇ ବ୍ୟାଗକୁ ଥାନାକୁ ଆଇ କହୁଛନ୍ତି। ତାମାନେ ମୋ ପଜିସନରୁ କିଛି ମିଳିଲା କଣ୍ଟ୍ରାବାଣ୍ଡ ସିଜ୍ ହେଇଛି। ମୁଁ ତ ମିଳର ଆରେଷ୍ଟ କଲି ତାଙ୍କ ଚିଫରେ କହିଲେ ସ୍ପଟରେ ମିଳର ଆରେଷ୍ଟ କଲେ ମୋତେ। ମୁଁ ଇନଭେଷ୍ଟିଗେସନ କିଏ ଯେତିକି ନେଲେ ମିଳର କେତିକି 2:30 PM ପୂର୍ବରୁ ଗଞ୍ଜେଇଟାକୁ ଖାଲି ଥାନାକୁ ଘିନିଲେ।
ପାରା 9
3 to 10 ମିଳର ମିଳର 3 ହେଲା ମୁଁ ଏତିକି ଇନଭେଷ୍ଟିଗେସନ ନେଲି 2:30 ରେ। ସେ କହୁଛନ୍ତି ମିଳର ତା ପୂର୍ବରୁ ଗଞ୍ଜେଇ ଆଣିକି ମୋ ଥାନାକୁ ଥାନା ରେଜିଷ୍ଟ୍ରେସନ। ଇଟ୍ ଇଜ ଏ ଫ୍ୟାକ୍ଟ ଦ୍ୟାଟ୍ ପ୍ରାୟର ଟୁ ମାଇ ଇନଭେଷ୍ଟିଗେସନ ଦି ସିଜ୍ ଆର୍ଟିକଲ୍ସ ୱର ରିସିଭଡ୍ ଇନ୍ आवर police Malkhana. I have not examined the police Malkhana in
and nothing is coming forth who has seized the ganja.
From whom seized the ganja?
Who has seized and from whom is again related question. You want to bring... No, that's what you want. Because nobody, who is the seizure witness?
Seizure witnesses is there.
Let us see the seizure.
It is a fact that I have not examined the police Malkhana in charge who received those seized articles. Even here, they received Kolebi Thana, she couldn't examine for me. I have not examined the police Malkhana in charge who received those seized articles.
Police Malkhana in charge has not been examined. Malkhana in charge not in.
That also creates doubt on the prosecution. I had a NDPS case state provision to comply with the Hon'Ble बहुत अधिक आज। I it's the case beyond reasonable doubt होगा। ये total आया पूरा doubt।
Don't tell me the general principle. Come to the evidence.
I cannot say who endorsed the concern entry in Malkhana register के दस्तखत कले मैं जाननी। I have not cited them as charge sheet witnesses nor examined them. Malkhana के रॉकले Malkhana, I cannot say who endorsed the concern entry in Malkhana register. The Malkhana register दस्तखत कर रखले मैं कोई परिबीनी। I have not cited them as charge sheet witnesses, not examined them.
Let us come to the seizure witness. Who are the seizure witnesses? I read it. I read full till 18. Question number 18.
I have not examined.
I have read it. I have read it, sir. Before you read. You proceed very slowly. By that time, I already. Tell me the seizure witness. Who is seizure witness? You have created a doubt, no doubt about it. Now tell me the seizure witness. One.
Independent.
Yes. Let us come to
Nothing
one.
was seized by the police in my presence. Of course, private seizure.
Nothing seizure. My please. PW1 seizure. PW1.
Then we have two. Nothing was seized by the police in my presence.
Yes. PW2. Not supported the prosecution. Not supported the prosecution. Yes. What is there else?
Then Miller, some relevant Miller, PW11.
11. Who is he?
Who is also a independent witness Miller as the women Miller. In presence Miller, the machine negates. I do not the informant at this point, he has also not Miller supported the person. I was in police, I have stated because I have more machine Miller, then Miller, and most relevant Miller.
Who has weighted the contravent ganja? Wait.
Chiba coach me PW11 again.
Wait, huh?
Oh. Chiba Bola, I am Janni Mokan the same one this Udon.
Yes. Yes.
Taku Miller କହିଛନ୍ତି PW13 ସେ ସେଇ କହିଛନ୍ତି Miller the Miller official seizure witnesses ସେ କଣ the ASI DN suddenly brought one woman namely Bittu Munda Bittu Munda not supported the prosecution case.
Yes.
Then Miller PW13 is also Miller related.
Who is 13?
13 Miller, as per the deposition of the PW 17 and 18 informant and the IO, Miller, the Jimanama given to me, Prachi given to me. But Miller, during course of trial, Miller, he specifically stated that he had not produced the Prachi before the Miller court during course of trial. Miller. That is Miller, straight away Miller. Cross Miller, paragraph 19. It is a fact that I have not produced the brass seal before the court at the time of production of the seed application.
PW13, huh? Jimanama.
And more importantly, Miller, who being the Miller official witnesses of the Miller prosecution, and Miller, whom the brass seal was given as per the evidence of the informant IO, same Miller, paragraph 15. It is a fact that the articles were not seized at the spot. एमान तो कहले आगे किछ हम जानिनु से भी कहू ना जो paragraph cross रे 15 then it is a fact that the articles were not seized at the spot.
Where are you
looking?
PW13.
Para 15 and para 19 ने कहला आगे मु brass seal देइनी 13 15 ने कहला आगे seized रे spot रे किछि contraband article seized. And that has been also Miller corroborated with the evidence of the PW 18. जे मु गली सब काम कली त गली किंतु गंजे सीझे rather more investigation
and PW 1 and 2 also has not supported.
rather से हम कहले से कोन जे मो investigation पूर्वरु गंजे आसी थाना
That is on 29.
Yes, Miller.
Yes.
And more so Miller on a bare period perusal of the entire evidence Miller of the prosecution. It's a case Miller. This section 55, 52A, 42, 41 Miller not compliant. And
yes, madam.
Yes, my lordship. I will.
Now you got it.
Yes, my lordship. I will make a note.
Who has seized?
The magistrate. I have gone through
The
it.
IO doesn't say that he has seized. Teacher witnesses don't support you. What else you have? You say that it was there in the Malkhana in charge was not examined. And the PW 13, Jimanama, he says that para 15 and 19 is very, very clear there. How will you get over this?
Yes, my lordship. I will satisfy.
When will you satisfy?
Everything has been written.
Otherwise, I'll grant bail at least.
No, my
He's
lordship.
entitled to bail.
My lordship, while passing the.
There is a case of acquittal. Why are you worried about it? If she can't satisfy on this point, there is a case of acquittal.
Yes, my lordship.
I will not read anything else.
No, my lordship.
42 is clearly not complied. The person who was supposed to comply, he says that I have not complied. Conveniently, he says, read para 7 and para 24.
Yes.
He says that I have not noted down, I have not, I have communicated, but and which mobile phone I have communicated, he doesn't know. Though 42 is not complied. 52A and 55 is also doubtful because of PW 18, 17, 1, 2 and 11 and 13. Next week, you satisfy me. Otherwise, at least he's entitled to bail, if not anything else.
ତାପରେ ଯଦି ଖରା ଛୁଟି ପରେ ଟାଇମ ପାଇଥାନ୍ତେ ଭଲ କାହିଁ କରିଥାନ୍ତେ ପଢାପଢି କରି ଆଜି ଯଦି ଅବଜେକ୍ସନ କଲେ ମୁଁ 37 କିଲୋ
You could successfully made out a case for bail at least, if not acquittal, subject to what?
ଛୁଟି ପରେ କରନ୍ତୁ ହିଷ୍ଟୋରୀ ବେଲେ ମାଗିଲେ ଦିଦି ଟାଇପ ଦେଲେ ବହି ଫହି ଆଣି ଅବଜେକ୍ସନ କଲେ ଯେ ମୁଁ ଡରିକି ପଳେଇଲି
You satisfy me. Otherwise, at least he is entitled for bail.
Please, one Lordship.
Yes.
My Lordship, kindly have a class to 114, my Lordship. PW7, my Lordship.
7?
Yes. Only 42 I am just placing.
Yes.
My Lordship, may I read the deposition?
PW7, huh?
Yes, my Lordship.
Yes, madam.
I was walking in my on 29/1/2021. I was walking in my present post as ASA of the police in Balangir town place. On that day, we are performing patrolling duty at the night. So and so, all the facts, my Lordship. Then the SI informed the IIC, who advised us to block the road on that at about 3:55 AM that the vehicle came.
Who is he?
He is a ASI.
He was one of the.
Yes.
ସିଏ କଣ କହିବେ ଇନଫରମାଣ୍ଟ କହିବେ ନା କମ୍ପ୍ଲେନ୍ କରି ଇନଫରମାଣ୍ଟ ତ ଚିଫ୍ ରେ କହିଛନ୍ତି କ୍ରସ୍ ରେ ମନା କଲେ ଆଜ୍ଞା
Therefore, I'm saying you are at least entitled to bail.
ଆଜ୍ଞା ସାର୍
Subject to, may not be acquittal because the other evidence, he will read it out, obviously.
ଆଜ୍ଞା ମୁଁ ତ ସେଇଆ କହୁଛି
See, the party, those who have accompanied with the informant, who is an officer, he says.
He's only said civil PW17 को कोई भी कंप्लेंट किंतु क्रॉस रे मना कला हम ये को नोट डाउन करिबे ना कोन इन्फॉर्मेशन आपको को इन्फॉर्मेशन आसीथिला ना कोन
But he will only
पेट्रोलिंग
place
करथला बेले इन्फॉर्मेंट पाइले इन्फॉर्मेशन he support to be note down this ये खाली
he only my Lordship will
He says that on search, we recovered 2 number of plastic bags
Yes.
containing ganja
Yeah.
on smell, and we detained the vehicle.
Yes, my Lordship. And I will satisfy each and every provision there.
केस 17 18 इन्फॉर्मेंट आईओ हेले
Okay.
आई माने
But reading the IO's evidence and the informant evidence, he is entitled to bail. May not be entitled to, acquittal, but bail, prima facie. See, the IO doesn't support,
Sees my Lordship.
and 2 independent seizure witnesses not supported you. He has created some kind of doubt on the seizure itself. We'll see, huh? Okay, please. Yes.
नेक्स्ट वीक
He could not join for briefing, my lord.
When do you want?
And next week, my lord.
Good date, take, okay. Yes.
30. Mr. David at the Mapatre is appearing in this matter since he is not very.
Okay, on behalf of Devi Datta Mahapatra, adjournment, yes. Next,
31. Interim order.
yes.
May I please, Your Lordship?
Yes.
Your Lordship, may kindly see order dated 21/2025. The Lordship was pleased to send the matter to mediation. The OP number 2 refused to cooperate with the mediation center and did not join the law. Thereafter, did not attend the court either by herself or to her advocate. And another advocate has, my lord, my learned friend has, my lord, last occasion also joined. And it is the petitioners are the in-laws. The petitioner number 1 is the mother-in-law. Second is the sister-in-law working at Bengaluru. Third is the married sister-in-law. And fourth is the brother-in-law, sister-in-law's husband, who is a police officer. And the Lordship may kindly see the OP number 2. Earlier lost 2 criminal cases under Annexure 2, 3, 4, 5. They are FIR and charge sheet.
Where is the mediation report? Let us see whether.
Mediation report is there, my lord, on record.
Okay.
Lordship, mediation report dated 29/2024.
Where does it say that she has not participated?
The opposite party, the counsel for the opposite party further submits that the opposite party has refused to cooperate with the mediation.
Where are you reading?
Like the second paragraph, my lord, mediation reports. The Lordship,
I just.
this mediation report.
Is there petitioners are present in the council? And the counsel for the opposite party is also present before the mediation. So the counsel for the opposite party further submits that the opposite party has refused to cooperate with the mediation. Yes, yes, sir. Very.
Fourteen 2024. The Lordship's order.
Yes, yes.
At the time, another concept was there.
No, that's not fair. The court says that you go and participate in the mediation. It is a matrimonial dispute. First of all, you have not gone. He came and the mediation report came. Then he intimated this court. Then another counsel appeared, says that yes, I'll go now. Even then he didn't go. Again, the mediation report comes and says that it is unsuccessful because you have not cooperated. Now he has changed the counsel. What is this? She can't do that. She can't disrespect the court of order of the court like this. And very conveniently she changes the counsel. Because the earlier counsel has given the consent to appear. This is not acceptable. Tell her to appear in person. She can't do like this. It's after all the court's order. No court can force you to settle. But at least you should participate and say simply that I am not interested. How can you disregard? How can you disregard the court's order? And why should the court will be with you? It is a matrimonial dispute. You have implicated everybody in the family. You have not left anyone. Who all are the petitioners, just see?
They are in-laws, my lord. Petitioner, no, husband is not before you.
Yes.
He is not
You keep on fighting with your husband. Leave the parents. And what is this adamant? Tell her to appear. Tell her to appear in person.
It's a dead matter.
And these people need to be, dressed down. Like, I don't know, this matter was referred to mediation by the matter is arising out of a matrimonial discord. Hence, on 14/8/2024, this court referred the matter to the High Court Mediation Center. The notice was served on the opposite party number 2. However, she did not participate in the mediation process. Therefore, on 26/9/2024, the matter was taken up by this court, and the counsel for the opposite party assured the court that she would be the opposite party would be appearing in the mediation center. Therefore, the matter was again relegated to the mediation center, and now the mediation center has submitted a report in stating that the opposite party has refused to cooperate with the mediation process. Hence, the mediation remain unsuccessful. Since this court has relegated the matter to the mediation center, and the counsel for the opposite party has assured to participate in the mediation center. However, subsequently, they have disregarded the order of this court. The opposite party number 2 is directed to appear before the court in person, either through VC mode or physically or through video conferencing mode on the next date of hearing. Next, relegating the matter to mediation center is not compelling the parties to settle the dispute. However, it was expected that the parties would have participated in the mediation process. However, despite the assurance given by the counsel appealing the parties to participate in the mediation process, the party has refused to participate. Hence,
Interim order to continue.
Interim order to continue. Give after 2 weeks. They will stay.
Yes. You also may call it in face admission in the heading.
Yes, sir. Yes.
Yes, sir. 32.
Today, opposite party has changed the counsel, so and so entered appearance and seeks an adjournment.
My lord, may I please your lordship, my lord, I am for the opposite party number 2, wife informant.
My lord, I am the petitioner, father-in-law and mother-in-law. In this case, informant opposite party number 2 is a senior bank officer, my lord.
Yes.
Parents, my lord, very pathetic conditions, and the informant appear and file his counter. Annexure C by 2, that is a divorce petition filed by the informant wife against the husband. I say admit करचिन ताकर running page 30-31 रे जे बाहर only very short period they are separated. So in the conditions, my respective submission proceeding was against the father-in-law, mother-in-law.
No, that may not be the ground.
My lord,
That can't be a ground.
my lord, only allegation of the 493.
Let us see what are the specific allegation against you. Let's see
Husband
that.
against my lord.
Huh?
Husband against it.
Let us
ये
see.
चाकरी करची बाहर से चाकरी ये क्लास 1 अफसर अछि बैंक
Let us see from the record. See from the record.
allegation थिले ते मते मारिले पिटले रक्त बाहर कले 307 allegation बट पुलिस कले दिस टोटली फॉल्स only 498 304 DPI रे
Let us see the charge sheet. Let us see the charge sheet.
my lord,
Charge sheet.
May I please your lordship?
Yes.
So far I am the informant, I am reading. So far my affair is concerned, which has been annexed by the petitioner.
Yes, yes.
Yes, so I am reading out the relevant portion. After 7 to 10 days of marriage, my mother-in-law along with my husband came to my bedroom and told me to demand my parents another amounts of 15 lakhs to buy a house in Mumbai. I denied for the same. I know the financial strength of my father, but after 1 hour, my father-in-law, the present petitioner, called me and forced me to demand from my parents. Finding no other option, I informed the same to my father, but my father showed his inability the same day to my father, but my father shouted his liabilities to pay the same and inform the same to my husband and my in-laws. Hearing my father's denial, my husband and his parents
Terribly
scolded me in filthy language. As my husband along with his parents took me to bathroom forcibly, where my husband slapped me many times, and my father-in-law and mother-in-law.
We'll give 3. First, you go and explore the possibility. You want a dismissal right now. How do you know how much time it will take? Go and do it. Go and try and do it. You are facing a difficult case. Yes.
May it please your lordship. Item number 33, my lord. Your lordship heard this matter initially in the year 2010. The FIR registered, your lordship. In 2011, the charge sheet submitted. After 15 years of lapse, my lord, the trial has not yet been concluded. For that reason,
last order.
For that reason, your lordship.
Supporting my lordship. Because it is the case, my lordship, where one is the BDO and they have assaulted a BDO.
I am not on
that's
the
not the issue. Have you read the last order?
Yes, my lordship.
Last order, 1 minute, Mr. Shaw. Last order is para 2, just see, I have reproduced the trial court order. Thereafter, I said that it is surprising that the official witnesses are not turning up to depose before the court, and which is the cause of a delay in disposal of the trial.
Yes, ma'am.
And you are supposed to seek instruction on that.
That but not I have not received.
See, this FIR was registered in long wake, and the official witnesses are not coming.
Yes, ma'am.
So why should he suffer?
My lord, the learned counsel.
What is the
was
instruction?
Give me a last chance, I will take the instruction.
See, that's the order. Just see the first order. You have not read the order. Who
It
appeared
is the
last time?
order of 11th February.
Madam, you have been appearing in this matter throughout. No, last time Vivekananda Naik. That's you people have the same problem. And 2nd December 2024, you appeared. And 7th February 25, Mr. Vishwal appeared. Thereafter, 11th, 12th, 2025, Mr. Naik appeared. What is this happening? I passed in 2 matters, I have passed it and communicated to the Advocate General. Still, you are continuing with this. There are 3 hearings in this case. In all the 3 hearings, 3 lawyers. Why are you doing all this thing? I don't know. Where is Mr. Naik? Vivekanand Naik? Today he disappeared. Last time Mr. Vishwal appeared. First you appeared. I think you are playing a trick to get an adjournment, it seems. In 2 matters, I have very serious observation. I have made it and sent the file to Advocate General. What to do now? Seek instruction in this. If you can't procure these official witnesses, your own witnesses, drop them. But accused can't suffer like this. It is your own officers. Why can't they go to the court and depose? Then why have you cited them as a witness? He was a video and video, one was video and another is some officer.
Complainant himself is also not turning up.
This matter was earlier taken up on 2/12/2024, where Mrs. Sarita Maharana appeared for the state. Subsequently, when the matter was taken up on 7/2/2024, Mr. S.N. Vishwal appeared for the state. And thereafter, again, the matter was taken up on 11/2/2025, where Mr. Vivekanand Naik appeared for the court. Today, when the matter is taken up for hearing, Mrs. Maharana appears for the state and submits that she has not received any instruction pursuant to the order dated 11/2/2025 and seeks an adjournment. Seeks an adjournment. The change of counsel on behalf of the state on each date of hearing has been deprecated by this court in earlier occasion. Still, the practice is prevailing. Be that as it may, one more opportunity is granted to the State Council to obtain instruction pursuant to the order dated 11/2/2025. It is expected that on the next date of hearing, instead of any other counsel, Mrs. Maharana shall appear in this matter and seek instruction without fail. Please the matter next week. That is on 17th. 17th.
Grateful, man.
See, if you don't bring the instruction, what I'll do is I'll record everything. I will straight away record an acquittal. I will not wait for anything. Whatever material may be there or not, I'll simply record an acquittal. I say that the official witnesses could not be produced by the state despite repeated intervention of this court. Therefore, simple acquittal. We can't wait for your grace, Yes.
34.
Interim order to continue.
Interim order to continue. There is a bereavement in the family. Yes.
35.
Yes, madam.
Item 35.
35. Yes. This is for what?
For hearing, Your Lordship.
Hearing.
Yes, Your Lordship.
Who is appearing? State.
Mr. HB.
Okay, password. Let's read. Yes. Mr. HB, you are most sought after.
On Saturday, if I have been sought after, then it's very difficult.
What to do? All vigilance now. You prepared in any matter?
In fact, in the first case, that is Sarat Mahanti 283 of 2005.
Yes.
I need a paper book, man. I only have the appeal memo, nothing else.
Your
Are you
Lordship, I have the deposition copy. I agree that the paper book has not been.
I told you, in
Your
the pen
Lordship-
drive, you take it.
No, we have everything that is there to be in a paper book, Your Lordship. Only the deposition
that bunch
copy
of
I can serve, Your
That
Lordship.
bunch of copies can be
Prepare
shared.
whatever you
Because
have.
earlier it has been served,
he
that is
has-
there. Earlier it has been served to the state that is there in the order sheet, Your Lordship.
I would only request both of you sit whatever document you exchange each other, and
Okay.
so that I'll put it in the weekly list.
My
and
only predicament is, Your Lordship, this appellant is now 86 years old.
Still alive.
Still alive, going to.
Is this offense under?
7th.
13, 7, 13, 1, Your Lordship.
Trap, it's a
1
trap.
minute. 1 minute.
It's a trap case.
Trap case.
Yes, Your Lordship.
When was the FIR?
Is of the year, Your Lordship, 19.
FIR of 90 minutes.
2009.
1990.
90.
Yes, Your Lordship.
What do you want then?
6 witnesses, Your Lordship. Informant complainant himself has turned hostile. Overhearing witness, hostile, Your Lordship.
We'll do that section 5 proviso.
Yes, ma'am. That can be worked out.
That will hamper my provisional pension, Your Lordship.
And you, I don't know whether you die or you survive. You want pension now.
Your Lordship, pension is needed because he is not able to meet his medical bills, Your Lordship.
Then it needs to be, if you
Yes,
want a clear acquittal, then
Yes, Your Lordship.
Has to be heard.
exchange. If you are sure that you have a good case,
Yes,
for
Your
it,
Lordship.
then get ready.
I'll
So
serve
priority
the-
kuri 86 na before he's not getting family pension, obviously not.
No, Your Lordship is not getting family. pension.
Children are the
Children, one
wife is there.
wife is not there. Only one son is there, Your Lordship. But son's income is not enough since he has suffered stroke and all, Your Lordship. He has huge medical bills. So that is why I have been pressing for this case. The son is not able to meet his
Then
medical.
weekly record top rep and exchange it immediately.
Your Lordship.
And prepare. Have you prepared the note and all?
Yes, Your Lordship.
You have prepared the note.
No, madam.
Prepare a note. Give it. Prepare a note. If it's the case of acquittal, I'll pick it up and
Your Lordship.
only 6 witnesses we can.
Yes, I have to be very fair and be short.
Yes. Yes.
Your Lordship.
Weekly first item group. Weekly.
Your Lordship may also order for making of the paper book because that will be easier for the
If
counsel. Or
the
else we'll
paper
take
book,
it-
if I'll record that, then it will delay.
No, yeah.
Better you exchange yourself,
it
come
with
and
it. Yes.
come with written note, I'll dispose it up.
And
Yeah,
then exchange whatever papers they have.
You exchange yourself and
Scan it.
get ready.
Yes, please give me a hard.
Yes.
36.
Maybe.
This is the oldest case, it seems 90, no. Prior to
Yeah.
that. No, but the appeal is 2005.
Yes, Your Lordship.
Mr. Rijvi, why don't you find out what are the appeals of 90s? Do you have any appeal?
Your Lordship, there are 5, 6 appeals that were coming earlier initially. One, Your Lordship had disposed of in our matter. Another cancer patient matter also, Your Lordship had heard and kept it reserved. That
And
is of
I
1990.
will suggest you please give the number of appeals of 1990s.
Yes, ma'am.
90s appeals,
Ouch.
and list all these matter next week. Let us understand whether they still there survive or whether we can use that 5.
Once the appeals that are there on board, they are surviving. The appellants are very much surviving. We have taken enough.
We will prioritize those things.
Yes, that we can prioritize.
Huh?
Sort out with them.
Sort out quickly. So that at least those
Yes.
things. Yes.
Much obliged.
36.
Maybe.
Yes, Mr. Tripathi.
It is year of 97 man.
90?
1897.
Appeal of the year 2011.
2011. If your lordship go through the entire evidence,
so far as Birsa Wala is concerned, my lord. And up to there are 17 para in the judgment, my lord. Up to 14 para. Mine that there is a not whisper a single word against me by the decoy.
How many of
Two witness, my lord. Two.
No, no.
accused.
How many accused were convicted?
Two, my lord.
Two. What about the appeal of the other?
Also pending.
Both the appeals are listed today.
Both listed.
You are talking about now Birsa.
I am arguing that
Birsa.
Birsa.
What about your second? You are
Yes.
appealing. Second appeal you are appealing. You ready?
He is appearing to 44 of 11.
Your Lordship, in this case, Your Lordship, Mr. Pradhan will argue in this case. If my Lord and brother will argue today, Mr. Pradhan will argue on Monday.
ସେ ତାଙ୍କର ଚାକିରି ଆଉ ନାହିଁ ମୁଁ ଚାକିରି ପାଇବି 54 ବର୍ଷ 42 ରେ at the time of ଇଏ ମୁଁ DSP ହେଇଯିବା ନାଇଦର ମୁଁ ଥିଲି କି ଡିମାଣ୍ଡ କରିଛି ଖାଲି ଅଫିସ ରେ ମୁଁ ସେଦିନ ପ୍ରେଜେଣ୍ଟ ଥିଲି ବୋଲି ମୋ ନାଁରେ କେସ୍ ମୋ ନାଁରେ ଏଫଆଇଆର ମଧ୍ୟ ନାହିଁ
अच्छा, let us see.
You lost your heart.
Let us see.
Man.
Mr. Rijvi?
Yes, the paper book ready.
Paper book is there.
You lost your
Where is, give me the paper book. You have any matter?
I have 38 draft case. Item 38.
If I pick up one matter or two, I don't think the rest of the matter can be.
Your lordship's paper.
Yes.
Your lordship, page 79. Except itself.
79. Okay.
Is the 313 statement. 79.
Page 79.
There are 313 statement. Okay. This is what the record says.
77
77 is our
paper book.
Question mark.
Paper book.
77 to start.
Okay.
प्रताप चंद्र पंडाल
अच्छा एफआईआर देखो Jay Madhav Swami is the complainant.
Yes.
He is a driver.
Madhav Swami.
Madhav Swami. His car was met an accident at CRP Square Meadow. Accordingly, two police officer of Noaipalli Meadow went to the spot and bring him the car with the driver. They kept him in the hazard. After some time, Pratap Ponda, who was the other co-accused, has asked him from 1500 and at the moment he paid 350 and he kept the RC book and the other papers of the car and released the car. This is the allegation.
I demanded 1500. He was having 400 rupees, 350 to 50 rupees he said at least for
Thereafter, he came to the vigilance office after 15 days and contacted.
So the entire allegation against is Mr. Ponda.
Mr. Ponda. So far as
he is appearing for Mr. Ponda.
Mr. Ponda. Mr. Ponda, my lord, there is 3 ingredients to be fulfilled under the PC Act. Demand, acceptance, and recovery. So far this is concerned, my lord.
You are nowhere in the picture.
No, my lord.
Yes. You are not there in this police station.
No, my lord.
Yes.
But if lordship can help.
How have you come now?
I have come to that, my lord. Since I have not entered the in the my lord that logbook, my lord, that police book paper, my lord. The car at that time I was in charge of that logbook of the police station. Since inspector,
You are in the constable.
no, I am a SI.
SI.
Since my lord inspector was not on duty, my lord, so I was in charge of that CD, case diary, my lord, that report, my lord. And since I have not that accident in the logbook, my lord, for that is, my lord, I was entangled and I am convicted under section 120B.
Show me the knowledge part that he has taken money. He had a knowledge. He has a knowledge. That's all.
If your lordship,
if you have a knowledge that Panda has taken money, thereafter, if you have done it,
Yes, my lord.
if you don't have knowledge, then you out. Show me the knowledge part. That's all.
And another thing, my lord, in this case, inspector was also a accused.
Panda.
No, my lord, inspector in charge, my lord.
IIC also.
IIC also.
He was acquitted.
I know, my lord. Sanction was sought for by the.
Sanction not given.
Sanction was, the IIC was given by the Home Secretary and Sub-Inspector by the DG Police. Home Secretary denied the sanction for the IIC. My sanction was given.
Show me the knowledge part. What is it?
Knowledge କିଛି ନାହିଁ ଆପଣ ଯଦି ଜଜମେଣ୍ଟ ରେ ଯିବେ 14 ପାରା ଯାକେ ମଧ୍ୟ ଗୋଟେ ଜଜମେଣ୍ଟ ରେ ଗୋଟେ ଧାଡି ନାରେ ନାହିଁ.
So far as this.
Let us see the judgment.
Exactly, man. Your Lordship, may kindly come to page 37, para 14.
Page 37.
Yes. So far as the culpability of this appellant is concerned,
Yes.
they have described. The learned code below.
Next point for determination.
14. So far as accused.
14. Huh?
My lord's verdict, man.
Para 14.
Para 14. Para 14 of the judgment.
1 minute.
Page 66 re.
66 Rasul. Okay. 66. Okay. Read it.
My lords, the sentence beginning.
So far as the
So far, my lords. May I place it, my lords?
Allegation against him.
My lords. So far as accused Birsa Barla is concerned, the present appellant, my lords, the allegation against him is that he and accused SI Panda had agreed with each other for not registering a case against the complainant for rash and negligent driving and had committed professional misconduct by abusing his position as a public servant. It is evident from the testimony of PW3, my lord, PW3 is the ASI, that on 24/7/97 SI Birsa Barla had made the SD entry number 626 with a exhibit 8/2, but no case was registered against the said entry and no officer was deputed to the spot. The evidence of PW7, my lords, PW7 is the guard of the CRPF gate who has witnessed this accident. PW7 has also found the evidence of PW7 reveals that he was an eyewitness to the accident and had informed his authority about the accident, who in turn had intimated the fact to the Nayapalli PS. This oral evidence of PW7 has also found corroboration in the letter written by Additional DIG CRPF to the OIC Vigilance Cell with Exhibit 27. But both the accused persons have not whispered anything on such communication of the Additional DIG CRPF. Though accused SI Barla was in charge of station diary on 24/7/97, he has not entered the information received from CRPF in the station diary. On the other hand, though the SD entry with Exhibit 8/2 made by accused Barla disclosed a cognizable offense, he did not register any case which is in contravention of the provision of Section 154 CRPC and contrary to the decision of the Honorable Apex Court in the case of Lallan Chaudhary versus State of Bihar, where it is held that provisions of Section 154 CRPC is mandatory and it is the statutory duty cast upon the police officer to register the case when a written complaint or otherwise discloses cognizable offense. As such, accused SI Barla had committed illegality in not registering the case against the decoy for causing an accident for which the then IIC had called for an explanation from him as evident from Exhibit 25. Lordship, Exhibit 25 is very important. Of course, accused Barla in his reply with Exhibit 26
reply and 25
is the explanation called sought for. Yes.
Yes.
Of course, accused Balla in his reply with Exhibit 26 has taken the plea that he was the only officer present at the PS till 11:15 p.m. He had no chance to leave the station diary and to take up inquiry, but this is not believable that no other police officer had come to the PS till 11:15 p.m. Rather, SD entry number 630 at 2:45 p.m. on 24/7/97 reveals that IIC had returned to the PS after attending crime meeting. So accused Balla could have intimated the IIC about the accident and could have gone for spot inquiry. SD entry number 633 at 6 p.m. also discloses that the IIC was present at the PS and had detailed advance duty among the present PS staffs. Further, accused Balla in his reply, Exhibit 26 has mentioned that after handing over the station diary to SI PC Panda at 11:15 p.m., he had made local inquiry about SD entry number 626, which is also not free from suspicion because by the time he was called for explanation by the IIC with Exhibit 25, he had not incorporated his findings of local inquiry. This is deliberate. But if accused Balla had made local inquiry, why he did not incorporate his findings against Exhibit 8/2 in the XD book? The reply of accused Balla also does not disclose the name of the witnesses from whom he had inquired about the accident to arrive at a conclusion that the driver decoy had acted in good faith. As such, accused Balla had not made any local inquiry as stated by him in his reply with Exhibit 26. Rather, he had not registered any case against the decoy who was taken to the PS by accused PC Panda, and there was pressure on him to pay them illegal gratification of rupees 1,500. And accused Panda had accepted rupees 350 from the decoy and had instructed to make further payment of rupees 1150 on 8/97, and his DL and RC book of his car were illegally retained by accused Panda as a measure of security to ensure effective payment of illegal gratification. As such, it is crystal clear that there was close nexus between the two accused persons and they had joined their mind together and hashed out the plan secretly to extort money from the decoy illegally.
Are you employing the preponderance and probability theory to implicate this kind of thing?
No, it's
Where is the link? Everything is correct. Where is the link?
Exhibit 25 and 26.
How can you bring 120B? Everything is correct. He has done complete dereliction of duty. 100% dereliction of duty.
Lordship knows.
Beyond reasonable doubt principle, you have to. How will you connect Panda with him?
So far, culpability under section 120B is concerned, your Lordship.
No, it's 120B is not presumption, sir. You can't bring 114 presumption and say that 120B is settled.
Conspiracies are always hashed in secrecy, my lords. Conspiracies, with due respect, my lords, have always hashed in secrecy. That's all.
Meeting of mind preceding the crime.
Yes.
First principle. 120B is an offense. Under the presumption, under 114, you can't this thing. And everything is correct. He is completely a useless officer. Everything is correct. He has not entered. Everything has happened. And he's given a plausible explanation also. That explanation is also
that has been discarded by the
tainted explanation. Maybe.
Yes.
But once you say that there is, he has not demanded, that's not your case.
Yes.
He has not accepted, that's not your case. Is only Panda has done it. How will you link Panda with him to bring one? You have to go strictly by the, the doctrine of proof beyond reasonable doubt. You can't bring preponderance of probability. See, till here I was carefully saying link. How will you immediately the preponderance of probability comes? Just see, read there. Read there. RC book till here it's all right. Culpability is somehow there.
Yes.
But once you link with Panda, because minus Panda you have no case.
No, my lords.
Minus Panda you have.
No.
So therefore the only test is how will you link with Panda? Linking factor, that evidence you show me.
Well, I would-
Any witness have said that I have seen that Ponda and the both of you were talking or doing anything of that sort?
Not a single.
Means I will examine that part.
And
That is the only point
Yes.
here, nothing else.
I will examine that one.
another thing, ma'am.
Hmm.
In this regard, there is an inquiry by the IAS. Why I have not made this stationary entry? I have give explanation.
I need not go into all that.
He was satisfied. Since there is no rash and driving, my lord. For that, there is no cognizable offense. Happens and he has not made the SDN.
No, those things are not relevant.
Again.
You are being prosecuted for PCR under the aid of 120B.
Yes.
Then Ponda is the principal accused.
Right.
Unless you are linked with Ponda,
Right.
unless a knowledge attributed to you that Ponda has taken money, you knew that.
Yes.
Somebody, somewhere, anybody has said.
Madam, 13(1)(d) is always there, madam.
But 31D must be
13(1)(d) is there.
Dereliction of duty, 13(1)(d).
No, madam. Madam, can you see?
Anything recovered from him? Anything? Let us see. PCR. Let us conclude this. At the end of the year, what does he say? He is convicted only 120B.
120B.
Where is that?
Same page, madam.
Same page.
As such, it is crystal clear. Lordship has it, madam.
Clear.
Crystal clear that there was close nexus.
Yes, there was crystal clear that there was close nexus. How will you get it that?
Malice. Nexus
Close
between,
nexus
between the two accused persons, and they had joined their mind together and hashed out the plan secretly to extort money.
This evidence to establish this finding.
Yes. To extort
how he has arrived at this finding.
Money from the decoy illegally, and in order to achieve their clandestine intention for extortion of money, they had committed series of illegal acts. It is needless to say that the offense of criminal conspiracy is always hashed in privacy, and so direct evidence is seldom available to establish the complicity of the accused person. So in an offense of criminal conspiracy, the attending circumstances such as backward and forward conduct of the accused, etc., are relevant factors for drawing an inference from one fact to another. That apart, the evidence of eyewitness to the accident, namely PW7, my lord, PW7 is the guard of the CRPF gate who was manning the gate, clearly shows that the accident had taken place due to rash and negligent driving of the car by the decoy, and accused Barla had no option to refuse registration of a case under section 279 and 337 IPC. Of course, DW2, my lord, DW2 is the defense witness, has deposed that there is circular of crime branch that if there was no rash and negligent driving and no person was injured in the accident, no case can be registered under 279 IPC.
Anybody was injured.
But my lord, this is important. But he has failed to give the circular number, date, year, and the defense has also not filed that circular in the court. Further, DW2 has initially named in the FIR as an accused, but he could not be sent up for trial as the government refused sanction against him.
DW1 is the IAS.
As such, he is
sought for explanation also.
Yes. As such, he is an interested witness for accused Panda and has resorted to falsehood. Though he had called for explanation from accused Barla, he did not pass any order whether the reply was satisfactory. So it can well infer that the cause of non-registration of a case despite receipt of definite information was an account of demand of rupees 1500 as illegal gratification which accused Panda had accepted from the complainant.
Yes.
Of course, the learned counsel for accused Barla had argued that the Vigilance PS case number is not mentioned in Exhibit 27 to show that the document relates to this case, and the IO has also not cited the additional DIG CRPF as a witness in the charge sheet, and so the document marked Exhibit 27 can lied upon. But I am unable to accept the submission of learned counsel for the accused Barla because though Vigilance PS case number is not mentioned in Exhibit 27 from the contents of the document, it can be safely said the document relates to this case, and as the letter was written in connection with an accident on 24/7/97, which is also the subject matter of this case.
What is Exhibit 27?
27 to that letter of the CRPF that is an accident.
The communication made by the CRPF from the office of the CRPF to the concerned IS.
Yes. Letter dated 17/1/98. DIG movie. Is there that letter?
That's marked an exhibit.
Okay. Then your strength is only PW7.
Yes.
Yes.
PW7,
Plus, further, the non-citation of additional DIG CRPF as charge sheet witness is not fatal, as except writing Exhibit 27, he has no role to play in this case. The next submission of the learned counsel for the accused Barla is that none of the witnesses except the IO, PW10, has whispered a single word against accused Barla regarding conspiracy which warrants showing of undue favor in his official capacity. But such submission of learned counsel is not tenable because criminal conspiracy is hashed out in privacy and direct evidence is seldom available to establish the complicity of the accused persons. Therefore, in an offense of criminal conspiracy, the attending circumstances, such as backward and forward conduct of the accused, etc., are relevant factors for drawing an inference from one fact to other fact. In the instant case, from the facts and circumstances discussed above, the criminal conspiracy between the accused persons can well be inferred. It is contended by the learned defense counsel that after SD entry, IIC is only the competent authority to give direction for registration of a case if it is cognizable offense, and in absence of the IIC, as per the direction of the officer in charge of the IIC, but the IO has not investigated who was in charge of the IIC.
Page 72 at the last 3 lines. Having been found not to be tenable, last at the top, page 72 at the top. 72.
Paragraph.
My pages are different.
Paragraph 16 no last.
Accused Barla, having been found to have been tenable, this court is no other alternate but to hold that the prosecution has succeeded to bring home the charges in 13(2).
Read with section 13(1)(d).
PC Act and 120B so and so against the accused Barla and Pata. Yes, 13(1)(d).
Yes,
yes.
Obtains for himself or for another person. That is the catchwords. What should have it? Criminal misconduct by a public servant. A public servant is said to commit the offense of criminal misconduct. Then your lordship may kindly come to D. If he, my lordship have it, if he by corrupt or illegal means obtains for himself or for any other person. Now in this present case, he is obtaining on behalf of the Panda Mallards.
No evidence.
What has he obtained?
That's
not your case. If he takes money for Panda, I can understand. What is how 13(1)(d)?
I'm just placing my
read it.
If he by corrupt or illegal means obtains for himself or for any other person any valuable thing or pecuniary advantage.
This is not your case.
No.
He has not received anything from anyone.
No.
For Panda, it's all right, 13(1)(d).
Yes.
For himself, he has taken money. For Barla, how will you bring D?
Then by abusing his position as a public servant, obtains for himself or for any other person any valuable thing or pecuniary
advantage. That's also not there.
While holding office as a public servant, obtains for any person any valuable thing or pecuniary advantage.
That's also not there.
Without any public interest.
That's also.
So far the evidence is concerned. I will come to
has he obtained any valuable thing or any pecuniary benefit? That's not your case at all. So how will you bring 13(d)? And 13(d) is taken out of the book now after the amendment. How will you bring, how has he arrived at finding that 13(2) and 13(1)(d) is also made out against him?
I will examine that. I need some time to examine that.
You have a very difficult case. It's very difficult case.
Yes.
The case of acquittal. Yes.
I will go through once.
And if you want to convict, there are many ways of doing it, but it is a case of acquittal. Panda has a very difficult case, but he.
That is the reason.
Case, man. There is no acceptance, no recovery, nothing is man. It is a very peculiar case, man. After the incident, when they not found any that scented money from the Ponda matter, the SP.
It's not a trap case.
Not a trap case.
So tainted money, how will you get tainted money?
But it is a trap case.
I mean, it's a trap case, man.
Subsequently, it was trap.
Yes.
Or the remaining
Yes,
1100 rupees was paid.
Yes, 1150 was recovered.
Okay.
No, we recover not from a public placement.
From a table drawer.
From a table.
Yes.
The guy went to the police station and pushed that kid kept the money in a table. Man.
That is the defense.
No evidence is there acceptable. The two witnesses.
Partly heard. Partly heard. Please the matter for furthering. Prepare a note and give it. For Panda will see, but for him not.
My lords, may hear me for one. May hear me once.
Of course. These are criminal appeal. We have to. Partly heard. But we'll keep it. Aku weekly one question. Two. You have partly heard it.
1 week after, my lords. 1 week after.
Weekly ending. Item number 2.
Yes, but 1 week after, my lords. Only prayer is 1 week after.
You got an overall idea now?
Yes, my lords. Yeah. I will structure my arguments to your lordship's definite queries.
Yes. Yeah.
37. So, my lord, the paper book has already been filed, my lord. It's a case of misappropriation, my lord, by the appellant, my lord. And the already everything has been filed, my lord. Note of submission and the paper book, my lord. And in identical case, my lord, your lordship has acquitted the appellant, my lord. In the similar type of case, my lord. Here also, my lord, the sanctioning authority has not been examined. And it's a peculiar case, my lord. PW 3, 4, 5. They are the prosecution witness, my lord. They supported to the case of the appellant, my lord.
Okay.
And the petitioner, my lord, the appellant, my lord, he has adduced the evidence by DW 1, 2, 3 in support of his case. How the money has been misappropriation, how it has been adjusted. May I read the deposition, copy of the deposition, my lord?
Yes.
PW 3, 4, 5. They have supported to the case of the appellant.
Next.
And the sanctioning, more particular thing is that, my lord, the sanctioning authority, he has not been examined.
Sanctioning authority is
yes,
not examined.
Not examined.
Sanction is not proved.
If they are challenging that point of sanction so far is concerned, your lordship knows 2006 Paul Matthews, they have to raise it at that stage of trial. If they have not raised it in the stage of trial, they are precluded.
Taken that point there, argued that point.
Yes, my lord.
And if at all they have taken that point there also, it has to be
established
that
my
there
lord,
was
your lordship
manifest
judgment.
failure of justice. That also they have to establish. So there are two
similar judgment, my lord. This honorable court has quashed the judgment, my lord, relying upon the sanctioning authorities, my lord. Non-examination of sanctioning authority.
Which judgment?
My lord.
Which judgment?
Which year? Like 4 years was it?
Yes. Kishore Swain.
My lord.
Which para?
Paragraph. The relevant portion.
2018.
Yes, my lord. The sanctioning authority has to give the reasonable explanation, my lord, whether he has applied his mind or not. Not that he will shifted the burden to others. Justice Sangam Changu judgment.
There is an observation here. You say that it's mandatory. That's what
it is the duty of the prosecution to examine the sanctioning authority during trial, not only to prove the sanction order, but also to satisfy the judicial consensus that it was in accordance with law. By such examination.
Are you ready or not?
No, I am not ready. This case, my lord.
If not ready, then we item 3 for the parted goal.
Your lordship may keep it to parted.
Parted.
Yes. 38. This is my note of submission.
Hard copy.
38. And your lordship judgment is also there.
Sanctioning.
Similar.
Give these judgments to Mitchell.
Yes.
Yes. 38.
38.
He's not there. 39.
Mr. Naidu is there.
She
She was telling that she is ready. It's a trap case.
My lord, so far as 37 is concerned, that just Mr. Mishra was arguing that Yorkshire may keep 2 weeks after, because 1 week after.
Yes.
37, 2 weeks after.
38 urgent करो. Next week रख लो. Yes.
It will take only 15 to 20 minutes. Or I will take only 15 to 20 minutes. What my learned friend Mr. Naidu.
Actually, my lord, Ms. Naidu was on her legs in old building court number 3. She has requested me to intimate the honorable court.
39.
No, please, Lord. 39, Mr. Maharana was mentioning in the first hour.
Maharana is not well.
And that.
Your Lordship, kindly here because of Mr. Das last occasion, your Lordship said you have to come person, so I can. So Lordship, here my part, I am giving the written submission. So let him argue on the.
Just note it down. Let us see what is the case. Let us get the
overall idea.
Overall idea about this case. Like
On behalf of Ms. Naidu. On behalf of Ms. Naidu.
I'll put it next week. Sorry, I'll put it next week, madam. 39 will just
Next week.
39. You give me overall idea about.
Please, Lordship, that I have given some time,
but no, I just forgot it because facts are getting,
So here is a case, your Lordship, it's a trap case.
Let her come. Yes.
It's a trap case. According to the prosecution, they have recovered 3,000 rupees.
Give an overall idea. What is
Your
the
Lordship.
case?
So I will hand over the written argument, your Lordship. So that.
Give that to Mr.
Yes.
Rizvi.
Yes.
Yes.
In the case of trap case, alleged trap case, which also the documents to suggest that it's not a trap case. What happened?
It is no more or less. You have been convicted.
No, yes. That's
LAs can be at the state of trial.
It's also
the lighter side.
That happens. I cannot say that it is against me. It's decided. Question is here. One person was appointed by the superintendent.
Who are you?
I am the accused Ajit Kumar Sahu.
No.
I am an accountant.
Accountant.
But I am not in the role of doing any favor.
Tell me the facts of.
Yes. So I have given the facts. Only 2-3 lines I will read. That the appellant Ajit Kumar Sahu was convicted such and such case. I have not said. Prosecution case built on the allegation of bribe, demand of 3,000 rupees from complainant Chao Patnaik is based on severely flawed evidence, discrepancy in the complaint. Therefore, factual fact. Complainant mother worked as an attendant at Basant Manjari Nivas, Chandpur, under the jurisdiction of the city of Noyagarh. She passed away in 2003. Complainant Santosh Kumar was appointed as an attendant under the alleged rehabilitation assistance scheme on 5th June 2007 by the superintendent as Group 4 contractual employee. After 5 months of service, his salary had been not been released. He alleged that appellant who working as head clerk in the hospital demanded 3,000 rupees as a bribe to release his salary. On 6th June 2007, appellant allegedly informed the complainant that if the bribe was not paid by 11 a.m. on 7th November 2007, his salary would not be processed. Based on the allegation, complainant reported the matter to the SP, a vigilant Bhubaneswar, resulting case. KB Acharya, a senior officer, directed a trap to be set, which was conducted by the Inspector R.K. Ponda. Subsequently, a charge sheet was filed against the appellant under Section 13(2), read with Section 13(1)(d), Section 7 of the Prevention of Corruption Act. So this is the background of the case. Only question is in two court. Whether
demand is made by you.
No. No demand. Now only accept complainant, and there cannot be any demand also. I'll substantiate that there cannot be any demand, and I am not in a favor, cannot do any favor to him because
Para 6, you yourself said, para 6.
Please,
After
Lordship.
5 months of service, his salary had not been released.
Yes.
He alleged that
Yes.
the appellant
Yes.
and was working as head clerk in the hospital,
Yes.
demanded rupees 3,000
Yes.
as the bribe to release the
Yes.
salary. But there was an element of demand.
Yes. No.
They might not have proved, but
No,
the allegation is demand.
I'm not on that. I'm not on that. But I'm saying he was appointed by superintendent. Superintendent of the appointing authority by the group 4.
Yes.
That's why, your Lordship, kindly see page 22, 215. Page 215.
215 of?
That Talcott LC, lower court record.
215.
50.
No.
222.
No, what are you trying?
I'm saying.
No, what are you trying to show?
I want to.
The paperwork is consisting of only 92 pages.
No, not paperwork. I'm saying LCR, lower court record. LCR, it is before you.
What is which document you want to show?
I saw, your Lordship, page 205, 220.
What is the document you?
Document is the clarification of the appointment sought by the CDM.
Exhibit, please. Exhibit. It must have been marked as an exhibit.
No, it is a group exhibit. Totally. It's part of the document. So
Then,
document.
Yes.
It's very difficult to search that.
Locate it, yes.
You have.
बाहर कोई दियो तो सेटा बाहर कोई दियो.
बाहर कर दियो.
Show me that.
मेरी कॉपी दे दो. This is only photo. That I'll mark till that time. Time should not.
Yes. Yes, 200?
22. 215. 215 starts from 250.
22. Okay.
215. Your Lordship got it?
Yes.
215.
215. Yes.
Yes. Subject is clarification and submission of appointment file of
Don't
Santosh Chau Patnaik to go under this.
With due respect,
Party head clerk, dealing assistant, survey, appointment, personnel, file this. Then your Lordship kindly see the next page.
Yes.
This document shows that
where?
This document, I'll come to
Yes.
straight away that pages also. That 218, your Lordship can come to 218.
Yeah.
With reference to your letter, I am to state that ministerial staff at your institution may please be deputed in the office of the CDMO Noyagad in any working day, receive the personal file of Sri Santosh Chau Patnaik, contractual attendee such and such. Then your Lordship kindly see next very page.
Yes.
Office, this series of documents which they have asked clarification from the superintendent how he has been Santosh Chau Patnaik was appointed by the superintendent. Then your Lordship kindly see page 223. 223, your Lordship got it?
Yes.
223. It is a direct. It is subject is clarification regarding appointment of the Santosh Chau Patnaik, such and such, such and such. With reference to your memo number cited above, I have to state that in which ground you have been appointed Sri Santosh Chau Patnaik, class 4 contractual at such and such place. Please clarify to this office.
So what do you want to show?
Want to show that
it is more of a reason it is strengthening the prosecution case.
No, I come
because his appointment came in a cloud. So therefore, you gave a false this thing. I'll get your salary done. That's the case here.
Next part. Next same page. Next 2 lines.
Yes.
Copy and forward the treasury officer. You got it? Treasury officer for
information
and necessary action and requested to not to accept this salary.
Yes.
So salary was stopped by CDMO itself.
On 3/7.
Yes.
2007.
Yes.
Yes, when the
So
allegation.
once CDMO stopped this salary, CDMO is the higher officer. CDMO stopped the salary. His appointment is doubtful. Can a clerk, head clerk, even if clerk, can he release his salary at any point of time? No.
See, that's you might have given him the impression that
I can do
despite this thing I'll get
I
it
can
done.
do it, yes.
That's the case.
No, how can you?
Lordship, section 7(1)(d), your lordship are referring.
Let us see the allegation now.
Superintendent office.
I understood it now. Let us come to the allegation now.
Yes.
You say that the appointment itself is doubtful.
Yes.
Clarification is sought.
Yes.
And salary was stopped. That is
CDMO.
By CDMO. That is on 3/7/2007.
Yes.
3/7/2007. This has happened.
Please listen.
And when the FIR.
Then I'll come to.
Let us come to the FIR.
There are 7/11/2007.
7/11.
2007.
7/11/2000. Let us come to the FIR. Let us see. 7.
You can see
FIR.
charge itself.
7/11.
Page 34.
2007. No, let us see the allegation.
Allegation. The
Let us-
charge also will suffice. What is the allegation?
No, FIR is very.
FIR. Your lordship
FIR
can
is very-
start
Let us go to FIR.
starts from
Let us
30.
see the FIR.
Page 30.
FIR will see if you have given a wrong impression. It is
No.
not a mistake for- Let us
Page-
see.
It starts from
What
page
does it-
28. Page 28.
28
paper.
paperwork 28. Yes.
Your lordship, it starts from 31.
Yes. Reading.
Your lordship. ମୁଁ ଶ୍ରୀ ସନ୍ତୋଷ କୁମାର ଚାଉ ପଟ୍ଟନାୟକ ପିତା ବଂଶୀଧର ଚାଉ ପଟ୍ଟନାୟକ ସେକେଣ୍ଡ ପୋଷ୍ଟ ଅଫିସର ଆପଣଙ୍କ ଅଫିସ 7/11/2007 ତାରିଖରେ ଆପଣଙ୍କ ଅଫିସରେ ହାଜର ହୋଇ ଏହି ରିପୋର୍ଟ ଦେଉଅଛି କି ମୋର ମା ଶ୍ରୀମତୀ ସୁରମା ସୁନ୍ଦରୀ ଦେଇ ଚାନ୍ଦପୁରରେ ଥିବା ବସନ୍ତ ମଞ୍ଜରୀ attendant କାର୍ଯ୍ୟ କରି ଆସୁଥିଲେ 2003 ମସିହାରେ ମୃତ୍ୟୁ ହେବା ପରେ ରିହାବିଲିଟେସନ ଆସିଷ୍ଟାଣ୍ଟ ସ୍କିମ୍ ଅନୁଯାୟୀ ସେହି
Yeah. I got it. I read it. I read it already.
Yes.
Let us see whether these letters were marked to the Chau Patnaik. Letter was marked to Chau Patnaik. Does he have the knowledge that something is going against him behind his back?
Yes.
Where is the letter marked? Let us see.
Listen very well. Listen very well. And that is what I'm saying. I come to that. When I show your lordship the sanction part, I will show the.
See, come to the point.
Yes.
Come to 224.
Page 224.
Come to 224.
Yes, 222.
In between. This letter whereby his salary is stopped.
Yes.
In 3/7/2007.
Yes.
Has already been marked to Chau Patnaik. Just see, copy to Sri Santosh Chau Patnaik, son of so for information and guidance. You are not reading that part which is important.
I'll come to that.
Yes.
Yes.
You have not read that. Your case should be the salary was stopped on 3/7/2007 and there is a letter circulated to everyone, including the informant. And despite that, on 7/11/2007, he is believing Ajit Patnaik, who is head clerk, that he will release the salary. How can he release the salary if the superintendent was directed not to release the salary? That's your case.
CDMO, not CDMO.
CDMO, yes, that's the case. Yes.
Superintendent.
Let's come to the charge sheet now.
Yes, superintendent only appointed him.
Your argument is to 224, not 223. Anyway,
Yes.
let us come to yes.
Then your lordship.
The evidence.
There are two facets, your lordship. There is one, whether the sanction is proper, and another is there is a demand, which is a paramount necessity to fasten the liability or convict me under section 7 and 13(2). Section 19, your lordship, is the sanction. Thanks, sir. I'll show your lordship.
Acceptance, which witness acceptance? Which witness? Trap witness, show me. You are accepted?
Yes, yes.
Where is that?
Page 68, 69, your lordship. 68, page 68. Your lordship got it? This is superintendent. And your lordship 69.
Come to pay PW2.
PW2, your lordship.
Yes.
$445.
PW2.
May I read? Your lordship.
The relevant part.
46. 5 lines from the top. This is the contrary total cross-examination part, if Sir Lordship see.
Only one accused? Only
Yes,
one
only
accused?
one. Page 50, your lordship, 5 lines from the top, 4 lines from the top. I have informed the superintendent to pay my salary.
Come to page 46. That I had given the money and the accused has kept the same under the newspaper, and thereafter both the hands of the accused was cut and had the was of both the hands and were taken separately, and hand was washed and pink color, and the same was preserved and sealed in the glass bottle, so and so, so and so, so and so. You have accepted the money.
That will come. That will
come to 313 now.
Yes.
Come to 313. What is your explanation?
313, your lordship. I'll come to that. Before that, your lordship want to read this, then your lordship kindly see page 51.
I want to just know the entire this thing. Demand you have doubted, okay. But acceptance is there. Then presumption operates against you. In 313, what have you said?
313, your lordship, starts from page 35.
Last
Come
question.
to 313.
Last question.
Yes. Page 41, your lordship.
Demanded.
Last question, what do you have to say? What do you say, Jordan? Last question.
Yes. What do you have? Do you want to say anything about this case? Ragore case deichanti CTMO.
Why have you accepted? What is your explanation? That explanation has to come forth.
Yes,
I have the burden on you to say. You have to discharge that burden.
Yes, I said I have not received. That was kept in the.
Where in 313? Where have you said? Come to that.
Not put to me like this.
It was.
No. It has.
It is just denial simpliciter, man. Yes, denial meant simpliciter. That's it.
So what else?
The onus is on you to discharge that part. You have to explain why have you accepted, unless a story put forth by you and proved it.
Yes. If I say I have accepted this, then I should explain why and how I have accepted. If I say I have not accepted,
where have you said? The witness PW says that he has done it. You have taken it from his pocket. Your phenolphthalein test stood positive.
Yes, because what happened? That's the newspaper. That I will come to the story, and that has been elaborately discussed here. Newspaper, that day newspaper. I read the newspaper. It's my habit every day. So what happened in this paper?
Where from I'll get it? Where from I'll get all this thing? The story will not work.
Yes.
Evidence has to work.
Yes, I know that.
You can't build up a story, imaginary story, and on that basis I'll execute.
No. I've come.
Where have in 313, where have you said that I was reading newspaper, it was put it there.
So that way
I have not touched the note. Where have you said that?
No question was.
Defense evidence. At least show me the defense evidence. Because this has to be
corroborated.
This has to be proved by you, because the burden shifts on you once you accept the money.
Yes.
Wrong, right, whatever.
Yes.
Unless in 313 you say and lead your evidence
Yes.
to that
Yes.
effect.
Defense plea
that
matches.
presumption operates against you.
Presumption.
Then acceptance is enough, then conviction.
This honorable court, as well as the honorable Supreme Court has said that in trap case, presumption cannot go unless there is a demand.
Section 20.
Yes, section 20 only what? May I read one paragraph, Your Lordship? If Your Lordship will be right, I understand.
No.
So may I read only one paragraph?
Let us come to the point.
Last paragraph underlined.
My judgment also, I have also written this.
Underlined. What the Lordship is observing that is there. No. That underlined portion.
Your Lordship, may I read only one paragraph?
No, you have to get over that.
Yes, that may I read all these things? And in very recent judgment of the Honorable Supreme Court, 7th March, this 7th March, in draft.
Concrete material is clearly a wall.
May I read?
Once aspect of the demand and acceptance of the drive have been established beyond doubt, in our opinion, two views are possible in the matter, and thus the approach adopted by the High Court is preserved. This is directly. And I have also said, see, the scheme is demand is not there according to you, it's all right. I accept to that part, I am not venturing into. Insofar acceptance is there, and there are evidence, the trap party have very categorically said that you accepted the money, and they cut hold of your hand, and phenolphthalein test was conducted. Phenolphthalein test turned out to be pink, which is positive. That evidence has come. 1 minute, that evidence has come. Once that evidence has come, prosecution could successfully prove acceptance part.
Yes.
Then immediately the onus shifts to you, because section 20 comes in.
Props up, yes.
Once section 20 comes in, 313 statement, when it was put to you, you have to deny and put forth your defense, and you have to lead the evidence accordingly and establish that. To discharge the
313 statement vis-a-vis that defense plea that has been taken.
That's right.
That should match.
That also, Your Lordship, kindly come to page 5.
5, yes. Yes.
I have quoted one paragraph. That is very recent judgment. 2015. Satyanarayana Murthy judgment.
The most recent judgment, Your Lordship, is 2025, which my learned friend has just passed on to us.
Yes. And that is there. Apart from this,
25
in a recent enunciation of this court to discern the imperative of prerequisites of section 713 of the Act, it has been underlined in B. Jairaj Supra in unequivocal terms that mere possession and recovery of currency notes from an accused without proof of demand would not establish an offense under section 7 as well as section 13(1)(d)(1) and 2 Roman 2 of the Act. It has been propounded that in the absence of any proof of demand for illegal gratification, the use of corrupt or illegal means or abuse of position as a public servant to obtain any valuable thing or pecuniary advantage cannot be held to be proved. The proof of the demand thus has been held to be an indispensable essentiality and of permitting mandate for an offense under section 7 and 13 of the Act, to section 20 of the Act, which permits a presumption as envisaged herein.
Have you laid the defense evidence?
Please, Lordship.
Have you laid the defense evidence?
Defense witness, I have not laid, Your Lordship, because it was not required, and there is two passages.
It is required because read question number 20 to 25. 313 statement. Read question number 20 to 25.
What I'm saying, Your Lordship,
no, you have to meet with this first of all.
Yes.
Read 20 to 25. 313. Read it.
Please, Lordship, that I'll read, but what I'm saying.
You read it and get over this.
Your Lordship, that I'll do. What I'm saying, Your Lordship, at the moment, there are two facets of this. One is whether there is a valid sanction or not. One. Second is whether there is a acceptance, bribe, or I comes under bribe. Whether I, as per section 7, whether I'm empowered to do any favor to him, any gratification, I can do that. I have the definition of bribe also. I have to show your lordship that how this section definition works out.
You have to see the evidence.
So your lordship
Don't
going
read
into the
bribe definition. Who doesn't know bribe?
Sanction part, but superintendent is not appointing authority. He has admitted in his cross-examination. That is one. And he is not my sanctioning authority. Right, he's
Let
not
us
my
see.
appointing
Let
authority.
us see the how the trial court deals with the sanction.
Yes. Your lordship, kindly see the evidence part, then I will show your lordship the
Evidence, you have a very difficult case.
No,
Let us see the sanction. Let us see the sanction if I can help you.
Yes. Sanction, your lordship, kindly 69, page 69.
No, impugn order. How they impugn judgment. Let us see how he deals with it.
How your lordship see this? No. Your lordship 69 pages, actually 4 lines only. 4 lines only.
Yes.
It is a fact that accused is a class 3 employee. It is a fact that CDMO is the appointing and removing authority of class 3 employees.
Para 17 for the impugn judgment. Come.
Yes.
Come to para 17. PW6 is the same thing.
Married? It is submitted by the learned advocate for the accused that sanction order produced by the prosecution, Exhibit 15, is defective, for which the same affects the merit of the prosecution case. The sanctioning officer, PW6, Rajanikanth Bhadai, has admitted that CDMO is the appointing authority of the complainant, for which it cannot be said that sanction is legally valid. On the counter argument, learned PP submitted that General CDMO, who is the authority of the class 4 employees, is a district, may be the appointing authority of class 4 employee, but in this case, superintendent of the institute, which is an independent institute functioning directly under the health directorate, is the appointing authority. Further, the appointment of the complainant by the superintendent of the institute has been ratified by the director of health and the government. Hence, the sanction cannot be said to be defective. I have already discussed that appointment of the complainant has been ratified by the director of the health and government. The copies of the letters available in the personal file of the complainant sufficiently establish this. Otherwise, the contents of Exhibit 15 sufficiently establish that PW6 has held pre-sanction discussion with the stated that CDMO is the appointing authority for class 4 employees, but the same no way affects the authority of the superintendent either to appoint or complainant or accord sanction. Honorable Apex Court in Katina cases decisions held that other sanctions should not be.
How will you find fault with this finding?
I am coming to that. Once Group 4 employee appointed by the superintendent is questioned by the CDMO because he has no authority, that I saw the letters. So how can the superintendent say, and that I understand I could
The
have.
finding is his appointing authority ratified by.
There is no document to show that is ratified by anything. The appointing authority, it is a very not self case, your lordship. Appointing authority, superintendent, not appointing authority. Even Group 4, he appointed as a contractual appointee. That is also under cloud because CDMO said, how can you employ a person without my assent or my.
Come to PW6. What was your cross examination?
Please, lordship. That is page 68.
PW6. Yes.
I was working medical superintendent, Basant Manjari Nivas, Chandpur, Nayagarh, On that day, I issued sanction order, Exhibit 15 for prosecution against Ajit Kumar Sahu, head clerk of the said institution, at the relevant time on the requisition of SP Vigilance Bhavresh sir. He
Cross-examination 4.
Yes.
Question 4.
Yes, 69.
Yes, Mr. Only sanction part you just see.
I will interview with Mr.
Because
Mahara.
specific admission by the PW6. He says that the CDMO is the appointing and removing authority. Specific admission.
My lords, knows 2006 Supreme Court Paul Varghese case, my lords. When a question of sanction has been raised, first of all, it has to be raised at the initial stage, that is at the stage of trial. Of course, it has been raised. Then they have to establish how there was failure of justice.
Yes.
They need to substantiate it, my lords. They don't substantiate how there was failure of justice due to want of sanction.
Whether it was placed before him or not.
Yes.
All the documents, all these things are there.
Yes, my lords.
How I am prejudiced because the superintendent appointed that group of, and he was deprived of this.
No, that's
salary.
not the test. That's not the test. Test is something else. Because that is now Supreme Court has diluted that position. One rank officer down the appointing authority has granted the sanction. CDMO is the appointing and removing authority. A superintendent one rank down him has granted. Wow, how will you deal with it?
That will examine. I will interview Mr. Mahara.
There only the sanction is the only point where there is an argument, and otherwise there is no case.
Mr. Maharana, Mr. Maharana will be placing this matter. I will intimate him.
Last to section 19 of the PCF.
No questions.
Section 19(3) of the PCF 1980.
That I know that will create again problem. I know.
You are also kind of a class.
Yes.
Section 19 of section
3, yes.
Notwithstanding anything
Contained in the court.
The Code of Criminal Procedure 73A. No finding, sentence, or order filed by a special judge shall be revoked or altered by a court of appeal, confirmation, or revision on the ground of the absence
Or in error or omission and irregularity
irregularity.
and the sanction required. Yes.
And explanation A. 4.
Explanation.
Yes.
Error includes
competency of the authority.
Yes.
Squarely covered.
Verified on this question only.
That also statutorily creating problem for you.
So when it is clear.
If you are only see you are not questioning the sanction. Only see if the question of sanction comes where the evidences are not put before him, no documents were put before him. Mechanically, he has issued the sanction. In those kind of situation, you can attack the sanction order even in the appeal. But mere competency, your only question is competency. One rank lower than he is. Then three with explanation, one goes.
Not only that. No.
In that case.
Not only that. Kindly see the sanction order, your lordship.
No, then are you attacking the sanction order on the ground that materials are not placed before him?
I am attacking.
You are attacking only the competency. Competency goes with this.
He has no competency.
That's the explanation. On the ground of competency, you can't challenge. The conviction cannot be altered.
Yes.
That's what the section 19(3) explanation 1.
4A, 19(4)A. What it said, error includes competency of the authority.
Therefore, error on the ground of competency is not open for the appellate court to review the order. That's the law.
So then there is section 19 will be redundant.
Then the only point you
that will not then section 19 will be redundant. There is no meaning to write in section 19.
What? Why can't you? It's a very so simple.
Even this power.
You just tell me whether the sanction order you are challenging on the ground of competency or on the ground that materials were not placed before him.
See, in his deposition, the complainant said, I informed the superintendent my salary has not been released. So
You are going somewhere else. I am talking about sanction now.
I'm saying sanction because he's a prejudice. He was predetermined to prosecute me.
I can't go into that.
Because
Is there a bar?
I'm on deputation from Noyagarh to
There
here.
is a bar under the statute.
Yes.
In the statute, there is a bar.
19th. Yes. Statute clearly says that he is not a competent to grant me sanction. That is there. And moreover, second part is that bribe and the acceptance, that demand is a paramount, has to be there unless it is proved, and recent judgment also.
Even if there is no demand. See, the law is even if there is no demand. If acceptance is proved, burden shifts to you. It is a rebuttable burden.
Yes.
And you have to discharge the burden
So,
under section 20.
On that point,
Under section 20, you have to discharge that burden.
Yes.
Disprove why you have to explain on record that why have you accepted.
Yes. On that
And
point,
unfortunately, question number 20 to 25 specific questions were put to you. It is recorded from you. Your hand were tested. Phenolphthalein test is positive. Every question was very specifically put to you. You said michokota.
Simply.
And you have not laid
Any evidence.
corresponding evidence and a DW. Then even if the burden is apparent on record, you could not discharge the burden.
But
So therefore, even in the absence of demand on the basis of
acceptance,
admitted evidence on acceptance,
yes.
you can be convicted under the aid of.
I'll show from the evidence.
case, my lord.
I'll show from the evidence and be supported by so many judgments of this honorable court. I've cited only judgments of honorable Supreme Court and recent judgment also in trap case, particularly in trap case.
Yes.
So that has to be proved just because his hand will become pink. So that cannot be the only factor to punish me. Conviction. That cannot be the ground of conviction only.
That is a plausible explanation comes forth.
Yes.
Then you are right. If the explanation doesn't come forth, you simply say michokota.
Simplicity, man.
Gone.
No,
Come to section 20.
Yes, your lordship.
Section 20. Read section.
Once the
Only on section 20 I have cited.
Read it.
My lord, sir, note, my lords, once the acceptance has been proved, that is Raghuveer Singh's case,
gratification or other than a legal remuneration.
Read it.
Where in any trial or offense punishable under section 7 of the section 11 of the clause, section 7 or section 11 or clause A or clause D of the section 1 of the section 13, it is proved that accused person has accepted or obtained or agreed to accept or attempted to obtain for himself or for any other person any gratification other than legal remuneration or any valuable thing from any person, it shall be presumed.
Wait here.
Yes.
It shall be presumed unless unless the contrary is proved. Who will prove the contrary?
Yes.
Who will prove the contrary? Prosecution will prove the contrary or the defense will prove?
No, defense, I have said.
Where have you proved?
Your lordship, kindly see then for a moment, section 7, once again, your lordship. Section 7, your lordship.
Why are you unnecessarily wasting your time? You have to get over this. Have you proved it?
I have.
What is the scheme of law? Whatever evidence prosecution collects, it is put to the
defense.
Put to the accused. Under 313.
Yes.
And he has to give his explanation. If it is ordinary, there is no presumption, explanation is not required. Straight away, let them prove it.
Yes.
Beyond reasonable doubt, then you are all right.
Yes.
If there is a presumption, a statutory presumption,
yes,
then you have to offer an explanation and prove it. Then otherwise, the statutory presumption operates against you. On the strength of that, you can be convicted. This is the scheme of law. And there is a statutory presumption under section 20 because you are being charged for 7. And the fact that it was recovered from you, evidence has come recovered from you. It was put to you through question number 20 to 25. This is how it was recovered from you. You were, it was there in the newspaper. It was there with you. You are holding. It was recorded from you. Put to phenolphthalein test, and phenolphthalein
Positive.
test is positive. This is what the 313 statement. You said Michokota, nahi, Michokota, nahi. Okay? Then, despite knowing the fact that 20 is staring at you, you didn't do it. Even if you didn't do it, you should have led the defense evidence. You didn't do defense evidence. So the burden is directly on you, which you did not discharge. So 20 operates as simple as that.
At the time when I was inside the bathroom, that I will show. Everything was in the record.
How will you show? Defense evidence is not there. How will you show 20?
From their evidence itself. From their evidence itself.
Come to 330. Question 20 to 25. Read. 20 to 20.
That I have read also, Your Lordship.
Yes, read it.
My lord, so far as demand part is concerned, my lords.
Demand is not necessary.
Not necessary.
Now he has get over
the section 20 presumption.
20.
Yes.
That's the difficulty with him.
And once there is voluntary and conscious acceptance of money,
read 20.
Burden goes on the accused to prove.
20
to 25.
20 to
20. Question number 20. Read it.
Yes, it appears from the evidence of the above witness that immediately Santosh Das gave the signal to other members of the team. Those arrived in the spot and inquired from the complainant about the payment of money, and thereafter challenged you
about the receipt of the tainted money. But you at first denied. What have you to say? Michokota. Next. It appears from the evidence of the above witnesses that the complainant on query stated to the inspector KV Acharya that you have kept the amount in the newspaper. You have kept in the newspaper. What have you to say? Michokota. Next. It appears from the evidence of about and the vigilance official, that is KB Acharya, collected cash from your both hands separately in the sodium carbonate solution and which turned pink. What have you to say? Michokota. It appears from the evidence about the above witnesses that the solution were collected in separate clean glass bottle, duly sealed and signed. What have you to say? Nah. It appears from the evidence of the above witnesses that Amitabh Malik was instructed to lift the paper and to verify with the recover, and accordingly he counted and verified the tainted money by comparing the same with the numbers noted in the preparation report and found the same correct. What have you to say? Answer is nah. All these things are very specifically put to you, and
because I am not
could not
informed, I have to say.
In fact,
yes,
they failed to take the advantage of these questions.
This
had
very
been
specific.
explained.
He should have done it.
Yes.
Your trial. I'll tell you many a time what happens is the defense, because of the inevitable defense
lawyer.
conviction takes place. Anyway, this you are very deep of case. Spotted. Keep it. Keep it. Yes, madam.
I have a better case. I prepared a note so that whatever my lord's queries were, I've actually shortened it in a small note.
You got wiser by his case.
Well,
I'll put it in parhead and
yes.
But you have to get over it. It's very, very difficult. I try to find out from every angle. I was thinking of that we have some case on sanction, but Mr. Das and Mr. Rijvi demolish you from,
Recent judgment of this
no judgment will help you. Come to the statute. I can take a different view. I have already taken a view on section 20. I have already taken a view. So 19 is very, very clear. If you have challenged the sanction order saying that the sanctioning authority is not applied his mind,
yes,
no material is placed
before. That's a different aspect.
Then in that case, if your proper cross-examination is there, proper question is there, then you can doubt the sanction. He has not applied the mind at all.
Yes, he is prejudiced against me because I am deputed from the.
Don't say that you have not put that question to him. Where is the suggestion? You can't build up some story and tell me all these things. Where is the suggestion? I have read it. By the time you said, the moment you utter a word, I cross-checked with the witness. You not put a single word in a suggestion. You should have put a suggestion saying that since you are prejudiced because of this, you have done this. Where is that question? Now you are making out a story.
And from the
In the basis of story, appeals are not decided. Appeals are decided on the basis of the evidence.
Yes.
You built up a story, then you keep on building up 1,000 stories. How does it go? He may be prejudiced. He may be prejudiced. But have you put it to him? You not put it to him. So you are out. That question you can't argue at all. Yes, Mr. Mishra, you are telling something.
But a small mistake for the item number 22. I could not remain present at the time of call, madam, because I was engaged in another court, madam. ସେଥିରେ ବୋଧେ ବେଲଜିୟମ ବୋଲି ହଜୁର ଅର୍ଡର କରିଦେଇଛନ୍ତି ବୋଧେ that is not a Belgium case my lord item number 22 ସେଟା ବୋଧେ NBW
is
NBW ଅଛି but they are I have challenged the cognizance order so ସେଟା ତ
I will not interfere in cognizance that sentence I read it at the outset
ସେଇଟା ହେଲେ ଯେ NBW ଟା କ୍ୱାସ୍ କରିଦେଇକି କହିବେ ହଜୁର ଯଦି ମୁଁ ସେଠି ବେଲ୍ ମୁଭ କରି ରିଲିଜ ଅନ୍ ବେଲ୍ ସେଇଟା
22 ଦେଖେ ଦो you challenge the I'll give you liberty to challenge in the trial court the charge stage move up cognizance I'll not enter
ନାଇଁ cognizance ଟା ये प्रोब्लेम होची एथिरे वारंट टा इश्यू कर दैछन बिफोर cognizance जोथिरे जेतेबेले कि मु पिक्चर रे नथिली I was not there in picture my lord subsequently my lord during course of investigation the police submitted a report to the court and the court has issued a warrant against me my lord तापर charge sheet file hela after 4 years then my lord cognizance has been taken against me which I was not knowing my lord
cognizance which offense
20B cognizance NDPS
go on appear and get
ମୁଁ appear କରିବି you lordship say that NBW ଟା pass कर ଦେଇକିରି ମୁଁ appear କରିବି parity maintain करके से मोर bill टा
that those 22 ଦେଖେ ଦो
parity maintain
co-accused persons have already been
released by them
and you say that NBW was issued prior to taking cognizance you have been shown as absconder 22 jail must go no कह दो
तो छोटिया प्रेयर तो मोर से क्रिमिनल अपील ता पुनी बाहर गेला सब बेले लिस्ट
just see the criminal appeal
that is a very small matter which can be decided within 10 to 15
what I know is in small matter you never appear
no
I know that
no my associate
he also said the same thing small matter but many people don't appear in small matter
you should transfer all the small matters
to you he'll now send it.
What my associate will do?
I'll just give the number while he include.
89 of 2018.
Will include. Yes, madam.
My lords.
Yes.
My lords, here the first.
Give me a overall picture so that I can. Mr. Rizvi opposing you.
No, Mr. Das is this.
I just give a bare idea. I'm not because it's already 1 o'clock. My lords is already.
Yes. Give a overall idea.
Overall idea. The present appellant was the junior engineer.
Yes.
And the what had happened was this the informant, the complainant, he had taken an Indira Awas house. So I've of course given the chronology of dates as well. So I'll just give an idea. So Indira Awas house. The work of the JE, my lords, is that he used to go verify and then he used to sanction. So accordingly, the present appellant has gone, sanctioned the amount, and according in various dates, the amounts have been transferred to the. What happened is once on an inquiry for a separate house, when the appellant went, he found that the complainant, the informant, has misutilized certain things, and he was asked to reimburse that. That is all on evidence. It's not that I'm talking out of the record. So he wrote to the BDO that certain he may be asked to reimburse the amounts to the court. And because of that, the BDO said that you reimburse 1,500 was reimbursed, 3,500 was left out. He was told to reimburse 3,500 at a later date.
Yes.
Now, all this is under the sign and seal of the BDO. BDO has directed JE, AE, and cashier to see that the amount is deposited back. Now, with this state of affairs, the complainant informant, he goes ahead and lodges an FIR. The FIR is at page 35. He says, ବର୍ଷା ଋତୁ ଆସୁଥିବାରୁ ମୁଁ ଧାର ଉଧାର କରି ଘର ଛାତ ପକେଇଦେଲି। ଘର ଛାତ ସମ୍ପୂର୍ଣ୍ଣ କରି ଅଛି। ତ ବ୍ଲକ ତରଫରୁ ଆଉ 14 ବସ୍ତା ସିମେଣ୍ଟ ଆଉ ପଇସା 5,000 ଉଠେଇବା
ପାଇବାର ଥିଲା।
So this he says that because I was supposed to receive the appellant went, he saw that you raised it, you have not taken the dues. I will create the final bill if you give me 5,000 rupees. So this is the story which was developed. And when he went to give the 3,500, the vigilance officials caught hold of him. Now this is the story which I brought. But when he went for 164, as well as when he deposed, he advanced a separate story. Now, my lords, I will not go into it because my lords is already in a crunch of time. So when the 133, when my accused statement was called for, I gave a script. My lords will see at page.
Yes.
I've given the page numbers as well, so it is convenient.
Page
45.
Good. Yes.
Page 45 of the paper book, my lords. Here, there.
The complainant availed the money and cement under IAY him by showing the house of another person.
Right, lordships.
That's what you see.
Yes, sure. So that is the 160 in the accused statement. That is what I have said, and I have, but it was not gone into the. I have also raised defense evidence where the AE, because the BDO had directed AE, JE as well as the cashier. That, my lords, actually the LCR is not available in my lords sway because I had taken it by a pen drive long back. Page 180 of the LCR. My lords, if my lords will find the LCR at page 180, unfortunately the same is not available today.
You are referring to some exhibit?
Yes, my lords.
Yes.
It says that, should I hand over a copy, my lords?
You just give me idea because we will have here.
That exhibit says A, J, and cashier, and this handing it over so that my lords can appreciate for adjusting for the sake of the bottom line, my lords.
Yes.
Your lordship will see the starting. The beneficiary, Shri Amulya Jena, son of so and so, received an excess amount of rupees 5,000, which has been sorted out. My field verification. So he may be redirected to refund the excess amount. This is what I do.
Yes.
That is my signature. Then the beneficiary may be directed to refund. That is A's signature, my lords.
Excess amount is 3,000.
5,000 was there. Then he has returned 1,500. So he was supposed to return 3,500, which is then subsequently. Now your lordship will see please ensure A, J, cashier, same page, my lords.
Yes.
A, J, cashier. Please ensure the matter and receipt of the excess amount. So this is what the video has offered. Now the what has happened is the FIR was launched and other prerequisites will not go into today. Ballots is just clearing.
Yes.
The A conducted an exam. Now that 1,500 has also been deposited.
You examine A or J?
A.
What does he say?
He said that I have conducted an inquiry, and in that he has shown someone else's house and etc. But the learned court below has said it's an afterthought because that inquiry was conducted well after the arrest of the accused.
Then A's statement is in consonance with this notice. Then
my lords, the fact remains that so my consistent case is that I had 1,500. This is the case. 1,500.
You have discharged the burden rightly.
You're not just tried to. Now what has happened is when the question was put to, my lords may kindly turn to point number 16 of the note which I have just given.
Yes.
So that is easier for my lords to.
Yes, 16. Okay. Yes.
My lords. Subsequently, I have given the PW as well as the page number of the paper book, my lords. Subsequently, I went to the block, met the accused person, who was the J, my lords found it, informant. Para number, point number 16.
Yes, I'm there, informant PW. Yes.
Just quoted. Subsequently, I went to the block, met the accused person who was working as JE in Remira block and looking after the program and requested him to sanction the rest of all, for which he insisted his demand of rupees 5,000 for sanctioning the same, which is contrary to the FIR. Now, my lords, we look at the next sum. It is not a fact that my sister had never constructed any house by obtaining a loan from Hoodco. No, two negatives, my lord, is positive.
Yes.
It is a fact that I have stated before the magistrate and before the police that I was asked by the accused to make a new construction of house, otherwise to face legal consequences. Now, fact remains, he has showed someone else's house, taken the money. I found out.
Sister's house.
Sister's house, ABC, my lord. I'm not confused. He has shown XYZ's house, taken the money. So my thing was, either you construct the new house for the money you have taken,
Or otherwise you face legal
consequences, or return the amount. So he put me behind the bus instead. So this was the consequence. Now, my lords, we see the PW4. PW4, next paragraph, page, my lords.
Yes.
I'm sorry, my lords. PW3.
Three.
You
The accused carried the office of
I'll place my lord. Where the accused was carried to the office of the assistant engineer, wherein the accused disclosed that he has accepted the money for the purpose of depositing the same in some amount, which I barely remember. When the accused was challenged by the vigilance officials, he laid bare the fact that he has received the money from the complainant, which the complainant was to deposit in the office. Now, my lords,
Currency found in the floor.
that is not underlined. It was found in the Corona.
Yes. Who is PW3?
PW3, my lords, is the decoy witness, my lords. My beloved senior will correct me if I'm wrong.
Yes.
Same with post to
And PW4, what does he say?
PW4, my
The
lords.
complaint Amulya Kumar Janna narrated in the grievance that they Sripati also were demanding bribe of 5,000 to release the outstanding of 5 grants in 14 days of event.
So this is the IU, PW4, my lords. What I'm trying to now, Lordship PW4 IO has also said that he has not made any inquiry pursuant to what was being said in the EOs.
Before laying the trap, he has not made it.
It is not a fact. That also preliminary inquiry is not done. And also, it is a fact that earlier to the trap, the informant had paid, it is not a fact, rupees 1,500 to the accused towards the government dues. I have not visited or verified the Indira Awas house of the informant. What I'm trying to impress upon my lords is that the concept of rest case shape has been dealt with by this court in MPC Act cases, where it is clearly said that when the accused was taken into arrested, if any plea has been said by him, that should be taken around when investigation is done, subsequent investigation. Here, my consistent case, be that in the 130, or be that when I was taken into custody, or be that when the entire operation was gone into, has always been that they were dues, government dues, not my dues. It is not that I had taken a personal loan or otherwise.
That 3,500.
Yeah. So there are government dues which he had to repay, and that dues had to be deposited back into the account.
That are collected, and this supports these entries of that. Yes.
Now, the court below has taken the view that what is against me now? Before my learned senior starts, I'll go what is against me. Now, the entire file was seized. There were 11 sheets. It is alleged that there were 11 sheets. So the learned court below held, why wasn't this sheet or these materials seized? That is one part. Your options, the other part is, I have 1,500 which was deposited in the account has already been, 1,500 has been deposited. That part also has not been got it. The court below has said that means there is monetary transaction and that is admitted. He clearly says,
of course, there is a monetary transaction. Monetary transaction in this situation, but there is a reason of transaction.
Transaction is there. And the second fact being, the investigation agency have not even gone a step beyond to call for to verify with the BDO or the E as to what is the records coming. There is a consistent variation in the 161, 164 and the evidence led by the informant. Here he says, because I completed the house in advance, I was supposed to pay. And in the 164 in evidence, he says that I was supposed to pay because the final bill was due, which is contrary. That is one. Your Lordship, that is the sum and substance of the case. I will not go to it. It's already,
Yes, I am.
my Lords is sitting over time. So this is what it is. They, the money automatically has been received and partially it was substituted, deposited in the account. And I have received it pursuant to the order passed by the BDO. But my learned brother will argue with regard to the judgment which has later come across. That burden has to, the latest judgment.
You discharge that burden. You have discharged that burden.
Discharge it completely.
What is the worth of it, we'll see.
That is the only thing.
It's not that it's not a case, the earlier case. He has not at all done it.
Yes.
But you, yes, you have, yes, you have discharged that burden. What is the worth of those evidence that has to be gone into? That we will go into.
Lord, since my friend has heard it, I think he will reply with the next.
This is a trap case. Overall, 5 witnesses have been examined. PW1 is the overhearing witness. PW2 is the complainant. PW3 is the magistratal witness. PW4 is the TLO. And PW5 is the I. Your Lordship, overall idea your Lordship was going to, if your Lordship peruse the Exhibit 8, the FIR, which is only 1 page, your Lordship will realize the fact.
But the story now, when evidence started, the story goes in a different line altogether.
Evidence clearly proved regarding demand of this amount and acceptance by this appellant. Clearly from paragraph 13 of the judgment, your Lordship will visualize the fact that how the case has been proved in toto. Your Lordship may kindly only 1 page I am reading the FIR only.
No, I read it.
FIR your Lordship will be convinced overall idea.
But how the trial court had dealt with the evidence rebuttal he has done?
Yes, he has dealt with. Because the court, the learned trial court has asked 2 questions to the defense witness. What he has replied? Whether you had been directed, T court, DW1. Only 1 witness have been examined on their behalf.
Yes.
This appellant has not examined. He has asked whether the process of recovery had been initiated against Hon'Ble Kumar Jana, the complainant, for recovery of rupees 5,000 till the date of trap.
No.
Answer: till the date of trap, I had not initiated any process of recovery of advance amount of rupees 5,000 from Hon'Ble Kumar.
But what these entries?
That is there, my lords.
Your Lordship may kindly have a glance to page 17.
How this is the statement is contrary to the entries.
This statement of DW1 I am reading.
I know.
DW1.
Question 1, my lords. Whether you were directed or by any authority to inquire into the case. Answer: the BDO had directed me.
Yes.
Why? If BDO has directed, why didn't you initiate? Why you have replied in negative that I have not initiated?
See, the video has written, the AE has written here. Beneficiary may be directed to refund the excess amount taken.
The court has asked this question, not by prosecution. Whether, even if it is admitted that he has replied that the BDO directed me. Why didn't you take the initiation?
That is there, lords. Last page of the documents, my lord is.
He himself has denied. And this.
These documents were exhibited?
Yes, lords.
Through?
Your lordship, see.
Jesse?
With objection.
Exhibit B.
Exhibit B with objection. Your Lordship may have a glance to the evidence.
The entire notice.
Yes, with objection.
It is exhibited. The inquiry report is also exhibited. Last page.
This is the order sheet of the case record.
So it needs a little.
With objection, it has been.
Yes, little hearing it needs. Then again, part it could be the year. Third number 3.
May I pray that this exhibit, small exhibits are there on web of defense. May I be supplied with a set of.
He must have it. He will give you. Would copy these.
Your Lordship will visualize from the paper book paragraph 13 to 20.
I just wanted to get a overall idea. Now I got
only 7 paragraphs. Your Lordship will visualize the fact how far the case has been proved beyond all reasonable doubts.
Okay. Thank you.
Thank you.